checking that that's agriculture because
Have to turn it
in our new
off.
contract is with open
Right.
space.
But it's still making noise.
Yeah. Mm-hmm.
Some sort of noise.
Okay, I have the same thing, yeah. Mm-hmm.
Morning. Morning. Morning.
One.
They switched our spots.
Compliance.
Yeah, good, good, good.
All right, I guess we can get started.
Here, take a seat.
This is the hearing for Forest Conservation Variance Decision before the Forest Conservation Appeals Board. It was continued from November 16th, 2022. It's a de novo hearing, so anything you want in the record, if there's any further appeals of the matter, it needs to come in today at this hearing. So we can get started.
Okay, with your permission, I'll remain seated when I address you. My name's Clark Schaefer, 73 East Main Street. I'm an attorney representing Shorty Kuhn and his wife, the property owners, here today. And I'm sure, Mr. Allman, I do have a brief opening statement, but I think Mr. Allman will probably enter his appearance
Yes.
first.
James Allman, on behalf of the Carroll County Bureau of Land and Resource Management.
If I may, my understanding and reading of the statute is that this Board of Appeals is an ad hoc board that's appointed by the county commissioners if and when an environmental appeal, an appeal from an environmental regulation comes up. They don't come up that often, so the county does not have a standing, as you probably all know all this, the county does not have a standing Board of Appeals to hear these matters. I've been practicing for 40 years in the county in land use, and this is the first one I've ever handled or been in front of. This is, as Mr. Dixon briefly alluded to, this is a quasi-judicial hearing, is my understanding, meaning that you sit as both judge and jury, so to speak. Both you're to find facts, and you're to make interpret the law in accordance with the facts you find, and you're limited in your determination to what is presented here today. Now, Mr. Dixon used the word, the Latin phrase de novo, which we in the legal profession are very familiar with. What it means is it's brand new, essentially. I don't know what the literal translation is, but it means it's brand new. It's not appellate based on the record. So that means that your job is to decide whether, based on the evidence presented, the variance should be granted or denied, simply. You're not required to defer to Mr. Hines' decision. This is not, it may seem like it's an attack on Mr. Hine and his decision-making process, because there will be evidence that tells you why we think he was wrong and misread the statute and applied it incorrectly. You'll see, we do not believe that the review was fair, balanced, or in accordance with law. And appreciate your time because I'm pretty sure it's volunteer, to come in here and listen to these things. I would note for the record that I'm looking at because we're on the record here, meaning that if there's an appeal, the only thing that will go to the court would be a transcript of every word that was said here and evidence that's put into evidence. And then there would be no more testimony, or it's very limited ability. You can't put additional testimony on. So that may explain some of the weird processes here, and I'll engage in one now. I'm looking at the room that we're in the county building, and I'm seeing no one here other than Chris Hine, Jim Allman, myself, my client, his son, our expert witness, John Lemmerman, and John Bowman and David Beecraft, who work with and for Chris Hine. No other persons are here, and I just make that clear for the records because the record doesn't have pictures of the room. Thank you. I'm prepared to proceed with my case.
All right, the people that are going to testify, stand up and raise your right hand. You have to take an oath.
Everybody.
Do you swear or affirm under the penalties of perjury that the testimony you are about to give is the truth, the whole truth, and nothing but the truth?
I do.
All right, when you testify, state your name, your address, your occupation, and would you spell your last name for the record?
Clark, just as a point of order, since this is a de novo hearing, would it be the county that goes first? Because we are the ones that are putting on the case on why the variance should be, or I'm fine either way.
I think it's us because we are taking the appeal. We're the moving party here.
Okay.
Okay, everybody stand up. Did all my people stand up?
They did.
Did you stand up?
Yeah, I
and take the
stood
oath?
up, yes.
Okay, and I saw John and I know David did. All right. May I hand the board a copy of the variance section of the code? If you haven't already, if you give me in front of you.
I gave it to them.
You can highlight
The whole code.
Oh, that section, no, I didn't give that to
the
them.
sections.
All right.
Just wanted that to be in front of you in writing as we proceed through the hearing.
What section of the code is that in?
150.33.
I don't have it. Oh, 153.
And by the by, to add to my travails and troubles, as I'm working with these ordinances, yesterday I get in the mail the update,
Good luck.
which I've got it in this big book over there, that updates the environmental codes. So I didn't exhaust, and it's in a format that's not redlined, so you can't tell what the changes are. So I did take the trouble to compare, for instance, that section, and I think the changes were relatively minor, so it's pretty much the same ordinance we've been working from. But if anything comes up here today where I'm referring to something that's not accurate, please tell me, because you're more familiar with them than I am.
Absolutely.
All right, that being said, I'm willing to call my first witness.
Okay.
Okay, I call Chris Hine as an adverse witness.
Okay.
Chris,
I mean,
can you-
do you want to sit, Chris?
And why
can
don't you
sit-
bring him over closer to me, so,
All right.
okay, Mr. Hine, you were here and took the oath, did you not?
Yes, I did.
What is your position with the county?
I am the Director of Land and Resource Management.
And what bureaus do you have jurisdiction over, or are underneath you?
I have the Bureau of Resource Management and the Bureau of Development Review.
Okay. And how about zoning?
Zoning is under my purview, but it is not a bureau.
Okay. Anything else under your purview that's not a bureau?
Ag Preservation,
Okay. And then the Bureau of Resource Management is the group that handles the environmental reviews, correct?
that is correct.
And would it be fair to say that consists of the administration of the Forest Conservation Ordinance, the Water Resource Protection Ordinance, and the Stormwater Management Ordinance?
That is correct.
All right. What's your education and background?
I am by education, environmental engineer, have a bachelor's degree in civil engineering and a master's degree in environmental engineering. I'm a licensed and practicing civil engineer in the
Okay.
state of Maryland.
All right. Now, can you explain to the board, what is the overall purpose of the Forest Conservation Ordinance?
Forest conservation is derived from state law, which is to preserve the amount of forest within the state and protect environmentally sensitive areas and so on from a forest perspective.
And it works in conjunction with the Water Resources Protection and the Stormwater Management, and of course, there's the Health Department and all their regulations, correct?
No, it's a standalone ordinance.
Well, I know it's a standalone ordinance, but it's okay. The overall goal, though, would you agree with me that the overall goal is to protect / enhance the environment when reviewing development projects?
Sure.
And those various ordinances are designed to address those concerns, correct?
Yes.
All right. Now, is it possible, in this case, you have denied a variance on a .08 acre area of forest, correct?
That is correct.
All right. And your reasons you've stated in writing, and we'll talk about them a little bit more today, but as part of that, if that variance were granted, would the property owner, Mr. Kuhn, and even though his name's Walter, I'll refer to him as Shorty Kuhn because everybody else does, would he then have had to purchase an equivalent amount of forest in a forest bank?
There are a variety of ways that that can address the environmental impact. So that is one option.
Well, it's an option, meaning that if the variance were granted, that's what he could do to, he would have to do that to get the variance granted, correct? If the variance were granted.
Yes.
Okay. By the way, Matthew Herf just walked in the room. He's my new partner, and he's here to either watch me or help me, one or the other. Thank you. Okay, so now, what are forest banks?
So forest banks, and as you asked me what my area of expertise is, my area of expertise is civil engineering, and I oversee the forest conservation enforcement in the county, but it is not my area of expertise. So I will do my best to answer the question, but I would defer to Mr. Bowman, who is here also, that if you want
Good.
answers from that perspective.
That's fine.
But essentially, a forest bank is establishing, planting new forested areas in currently unforested areas to offset mitigation for development activities.
Okay, so, and if you think I should just talk to John Bowman about this, let me know, but I think even I know some of this stuff. So, forest banks are specifically addressed in the Forest Conservation Ordinance, are they not?
Yes, they are.
Yeah. And in order to qualify as a forest bank, is there a process and procedure that a property owner needs to go through?
We are starting to get a far afield of my area of expertise, so I would defer to John Bowman if that's an
we'll
important point.
call John. All right. But you're familiar with the essential mechanism, aren't you? And the essential mechanism is that a property owner somewhere in Carroll County applies for and establishes what is known as a forest bank on their property they own, correct?
Mm-hmm. Yes.
And once they get that certified as a forest bank, that person can then sell acreage, areas of that forest bank, to people like Shorty Kuhn, who needs it to comply with a Carroll County Forest Conservation Ordinance, correct?
That is correct.
Okay. And there, in fact, is an active market for that in Carroll County, is there not?
Yes,
Happens all the time, doesn't it?
yes.
Okay, and you have to, okay, so can you, is it possible for you to quantify in any way the net benefit to the environment that would occur comparing preserving this .08 acres versus purchasing .08 acres in a forest bank? Is it better? Is it better to preserve this .08 acres, or is it better to buy .08 acres in a forest bank?
No, I cannot quantify that. However, there is no provision in the county code that establishes any size limitations and so on regarding what can be varied and what can't. It is a black and white statement that priority one forest cannot be removed from the easement.
Well, then why are we here today?
Because a variance can be issued for any provision, technical provision of the code.
Oh,
But the code
okay.
specifically says that you cannot do that.
I got it. I misunderstood you, but so you can, a property owner can ask for a variance from the priority one forest, correct?
If there is an unnecessary hardship,
Yeah,
yes.
based on the criteria. I'm not trying to trick you or anything, Chris. Okay. And this property owner did, correct?
Yes, they did.
And you did in fact consider that variance request, did you not?
Absolutely.
And you did in fact deny it, correct?
Correct, I denied it.
Okay. So do you acknowledge that you had the discretion to grant it?
Yes.
Okay. Now, what criteria do you use to evaluate a forest conservation variance?
The criteria that's outlined in the code that I must consider.
Okay. And do you get these variance requests all the time, fairly regularly?
Couple per year. So I don't know if that in your mind is frequent or infrequent, but a couple per year
Well-
is regular.
Well, let me be, maybe I wasn't clear. Do you get variance requests from the environmental regulations regularly during the year?
A couple per year.
Your whole department?
The ones that make their way to myself,
No, okay, let's
Yes.
be clear. Does your department get a lot of them every year?
I don't monitor the number of requests that come into various staff. The way the process works is that my staff works with the property owners if there is a variance request, and they try and iron out all the details to put together good information. It only then makes its way to my desk for the final determination. So the number that come to myself for review, I would have to guess I've addressed 4 or 5, looking at all of the codes this past year.
Well, do all of them come to you, or do some of them not come to you?
No, the final variance requests all come to me for final determination.
And you're telling me you only did 3 or 4 in the past year?
To my recollection, yes.
Well, there was 2 of them in this application, weren't there? There was a
yes.
water resource protection and a forest conservation variance request.
Yes, there were. There were 2.
So this was 2 out of the 4?
Yep. And to my recollection, I can think of maybe 3 others that I've processed this year.
Okay. Now, so I think you just described when the variance request is made, it's usually made by the property owner's engineer, isn't it? Or
That's correct.
land use consultant?
Yes.
Right, and they fill out a form and send it in to your staff, correct?
Yes.
And do you know whether or not your staff engages in discussions with them and back and forth on these things?
Yes, they do, because my staff wants to make sure that all of the information that's necessary for me to be able to make an informed decision is present in the application.
Okay. Do you know whether or not your staff engaged in that process with regard to this forest conservation variance?
I believe so, but I couldn't speak to the amount of discussion.
Okay.
I wasn't privy to that.
Okay. Did you engage in that discussion when it came to your desk?
No.
Okay. Is part of your consideration in determining whether to grant a variance to balance and weigh the interest of the government versus the interest of the property owner?
I'm not sure how to answer that. I review as per the requirements that are in the county code.
Okay. Now, this variance application, when was it filed? Do you know? If I said August 30th, 2021, would that, I think that's in one of the, excuse me, I gave voluminous exhibits last time. Are they in evidence? Are they up there?
They're not in evidence, but they're up here.
Okay.
So it's
I'd like
exhibit
to-
1 through 6.
I'd like to move those into evidence. I think they're basically copies from the county files, and I've provided them to Mr. Allman 3-4 weeks ago.
I have no objection.
Okay. We move those in?
Sure. They're in evidence.
Okay, thank you. It's one of those technical things where you get to court and the judge says, "Did you ever move those into evidence?" Your Honor, I don't remember. Well, they're not in evidence then, Schaefer. Okay, so would it, do you disagree with me that August 30th, 2021, the off-conveyance application package was filed?
What I can state is that the documentation that I have here is that I received the variance request from my staff on June 15th, 2022. So that would be the earliest date, and that would be the date that I would have received the variance request.
Well, I'd like to refer to my Exhibit 1, page 1, which is a big, thick thing, but it's the first page. And it's a letter from my office saying, "Enclosed, please find our package for the creation of one off-conveyance for this property," and I won't read the rest of the letter. And it has a whole big package that you're required to submit with that off-conveyance application. Do you, I mean, I know is that true?
Yes, I mean, this is the first that I'm seeing this letter.
Okay, but that does convince you that that's when it was filed, correct?
Yes.
All right. And then on September 27th, 2021, John Bowman, who works for you, right,
Yes.
issued a comment letter that noted the forest conservation easement on the driveway parcel. Do you think that's true?
I have no knowledge of it, but
Okay, well, that's in Exhibit 1. I'll find that, okay? Now, does your file reflect, did you bring your file with you today? Or does John Bowman have it with him?
I have it.
John Bowman has it, okay.
Yeah, it does be-
John, are you checking me out on these things as I go through this?
That last day, Clark, was September 27th, 21?
Yeah, yeah,
That's correct.
okay. And then on February 22nd, 2022, okay, some 4 or 5 months later, does your file reflect that RTF, which is the land use consultant for Shorty Coon, filed the variance request?
Yeah, I have a letter
I'm
dated
just
February
gonna,
9th.
who's testifying here? Is it Chris
Well-
or Jonathan?
Well, it's Chris.
so as a.
But
as
if
a-
John
And you can
has
call John as a
information,
witness.
Maybe I can call him as a witness just temporarily with the permission of the board so he can sit up here?
And Clark, I have no issue with conceding the timeline of when all the letters were sent, and
Well, I'm
by the applicants and by the county.
Well, okay, I appreciate that. But I've got a little more meat to it than that. RTF requested the variance on February 22nd, 2022. Now, at the same time, RTF requested another environmental variance for the same property, did it not? The Water Resource Conservation variance?
There was a Water Resources Conservation variance requested. I don't have that file with me because that's a separate issue. But yes, I do recall addressing the Water Resources Conservation easement request, variance request.
Yeah, well, see, we think it's a big issue, so did you grant that water resource conservation easement?
Yes, I did.
Did you issue a written decision granting it?
Yes, I did.
And in that written decision, did you say that one of the reasons you were granting it was because there was no other area on the property where you could locate it, and that you found that the environmental benefits outweighed the detriment?
I do not recall, and I don't have my file here, but I would say that to me, there's a fundamental difference between establishing an easement and addressing a impact to an existing easement.
Well, but it was a variance request from the water resource conservation requirements, correct?
Yes.
All right. And if you look at Exhibit 3, page 5, I'm showing you, I've got a copy of what I've got you up there. Exhibit 3, page 5. If you see at the bottom of the pages, you can find Exhibit 3, the 5th page. I'm showing you a document dated, signed by you on March 28, 2022. Sure. And I didn't yell, I don't think I yellowed out on yours, did I? Okay. I yellowed some things on here or highlighted them. Can you tell me, and you can read the whole thing, what's that say?
The highlighted area?
Well, whatever you, I mean, yeah, the
that's fine.
highlighted area.
The highlighted area says, due to the nature of the existing site conditions, there are no alternative feasible options for the proposed development to the proposed lot.
Okay. Now, that's the same lot we're talking about here, correct?
Yes, it is.
Okay. Well, is there a different finding for this variance?
Yes.
How could you have a different finding for this? I mean, I'm not talking about a result. I'm talking about a finding. Is there a different factual finding for this result, for this case?
So again, like I just stated, to me, there is a fundamental difference between the establishment of an easement and the limitations that you're then putting onto a property versus an existing easement that's established and those impacts to the, to an existing easement.
Okay, I hear that. Okay, I disagree, but I hear it. Now, but, Chris, due to the nature of the existing, there are no alternative feasible options for the proposed development to the proposed lot. That's a factual statement, is it not? That's not a, I'm dealing with a different easement, I got lesser standards here or something?
Yes.
Okay, and that's no longer your factual statement when you refer to this forest conservation easement, is it?
For the record, I'm just going to object to this whole line of questioning for relevance. We are here for the appeal of the forest conservation variance denial, not water resource denial, not any other denials. We are here. They appealed the forest conservation variance denial. So I just want to put that on the record.
May I respond?
Every road, we will allow it and give it the weight it deserves.
Excuse me?
We will give it the weight it deserves.
Okay, thank you. Now, when did you find out about the alleged contractor's equipment storage yard that's on this property?
If you can answer it, Chris. That's
I would have found out about it when I received the package from John Bowman with the variance request, because it is mentioned in the variance request.
You don't remember, do you remember if you found out about it before then?
No,
Do you know if your department found out about it before then?
I do not know.
Does your department regularly inspect properties that apply for variances?
From a perspective of needing to know what is present on the property and what will impact the variance, then yes, that would be a matter of normal.
And you also have Google Earth available to you. You use that,
Sure.
don't you?
Sure.
Okay. And so would that process have occurred as part of the review of the water resource conservation or easement or variance request?
The water resources reviewer And again, I'm speaking to what one of my staff does as part of their regular course of business, and is they limit what they look at to what is submitted on the plan. And if I recall correctly, the plan that was submitted for the water resources variance request was limited to just the location of the southern part of the property and did not indicate, show the entire property. So that was the scope of what we looked at for the water resources easement variance request.
Well, in any event, it's clear then that you found out about you were aware of the contractor's equipment storage yard when you were considering the variance, the forest conservation variance request.
Yes, because it was documented in the report, the staff report.
John Bowman pointed it out to you.
Yes.
Right. And did you, after that time, did you send a letter to RTF, the land use consultant, saying, I will not be considering your forest conservation variance request because you have a zoning violation on your property? Please, and I'm paraphrasing, I've got the letter in the exhibits, please fix this, address this, and then after you do, you can submit a new variance application. Is that essentially what you said?
Yes, because I was, as I was reviewing the variance request, I was confused by the justification for the variance request, and felt that more information, and I requested that in my letter, that more information be provided in a future variance request. And county code also allows that if there is a violation of the code, Chapter 155, that we do not have to process further reviews and so on until those are addressed satisfactorily.
Can we hand a copy of that to the board, Mr. Ullman? Mr. Ullman has a copy of that provision of the code, and I'm familiar with it, but Jim, if you have an extra copy. Well, that's okay, I've got the book here, excuse me, I've got the book. Okay, I'm sorry, Mr. Hine, go ahead, you were telling me about that section?
Yeah, so 155.004B indicates that myself, the director, that preparation of a plan.
Why don't you just read the entire section B?
Sure, I can do that.
It's okay with me, but you can paraphrase if you want. It says, whenever Chris Hine finds.
Well,
Go ahead,
Director
go
of
ahead.
Land and Resource
Right.
Management.
Finds that any person, corporation, et cetera, or owner has failed to comply with this chapter or the rules or regulations of any other department or agency of the county in connection with the preparation of any plans required under this chapter, or has failed to perform any PWA, which is a public works agreement, between himself or herself and the county, the Department of Land and Resource Management may refuse to review any plans and refuse to grant any further approvals to such person, et cetera. So essentially, I have the authority to basically say, I'm not going to hear this because you are in violation of Chapter 155, which requires that the site development of a contractor's equipment storage yard needs to comply with 155. Now, subsequent to that, Mr. Schaefer requested that I go ahead and process the variance request anyways, which I then did.
Well, you were not aware of that section of the law when you sent that initial letter.
I object to that question.
Why?
You don't know what Mr. Hine was aware of.
I'm asking, that's why I'm asking him.
Well, I object as a leading question then.
Okay, were you aware of that section when you sent that letter saying, I'm not going to consider your variance request until you clean up the contractor's equipment storage yard? Were you aware of that section at that time?
Yes, I was.
Why didn't you cite it? You didn't invoke it then?
No, I did not invoke it.
Okay, in fact, not only didn't you invoke it, But I then sent you the letter you just referred to saying, hey, Chris, stay in your own lane, right? You can't link this zoning to this forest conservation. I sent you that letter, correct?
You sent a letter asking me to go ahead and process the variance.
I
which
object. Is that letter in evidence right now?
Yes, it is. It's 518. Dear Mr. Hine, this office represents I'll paraphrase. It's 518. We respectfully suggest that the alleged zoning violation, which your office apparently is prosecuting or asking that it be prosecuted, is separate and apart from the forest conservation easement variance request. Accordingly, we request that you immediately proceed to address the variance request. We will deal with any zoning prosecution that occurs when it arises. That's my letter, right?
Yes, it is.
And then that letter was dated August 10th, sent by email to you on August 10th, 2022, correct?
Yes.
And on August 15th, you issued your ruling on the variance, did you not?
Yes, I did.
And that ruling was denied, correct?
That is correct.
Right. Now, did you deny that, that variance because we refused to deal with the contractor's equipment storage yard?
No. And if I may point back to 155004B, there's a key word in there in the middle of it, which says that I may refuse to review any plans and refuse to grant. So essentially, I was allowed to refuse. You made the request, and then I decided that I would go ahead and process it.
But this is the first time you've ever mentioned 155.004 in any correspondence or communications regarding this matter, is it not?
That is correct.
Right. Now, let's talk about 155.004, okay? Have you made a finding that Shorty Coon has failed to comply with this chapter or the rules or regulations of any other department or agency of the county in connection with the preparation of any plans required under this chapter? Have you made that finding?
I have not issued a finding along those lines.
Well, you're telling me today you did, because you're telling me that's justification for you not to process the variance. Why would you rely on it if you haven't made that finding? Are you making that finding today here at this table?
Objection. This is about, he's not making a finding today. This is about the forest conservation appeal. This is not about his finding regarding an alleged contractor's equipment storage yard that may or may not be on the property.
Mr. Allman, Mr. Hine himself, in response to my questioning, said he relied on this section. Now, you don't want to talk about this section? I think it's totally relevant.
Overruled, we will allow it and give it the weight it deserves.
All right, thank you. So, you making that finding today, Chris?
I'm not sure what the,
You can either,
you-
if you're not doing it, you're not.
Finding, can you please
can't ask
restate
for
the
legal-
question?
You can't ask for legal advice. You're on the stand, bud.
Right.
okay, that's
Okay?
fine.
Are you making that finding today? Have you made that finding previously, or are you making it today?
And again, as you've indicated, the contractor's equipment storage yard question of whether that is a permitted or not permitted use of the property is an ongoing investigation with the zoning administrator. As an ongoing investigation, that would be my finding that that it is not in compliance with Chapter 155 until that has been resolved.
Okay.
Is that fair enough?
It's fair enough, but I got a couple follow-ups here.
Okay.
The first follow-up is, where do you get the authority to make a finding that a property owner has committed a zoning violation? Isn't that the specific statutory responsibility of a person known as the zoning administrator, which is an official statutory position?
Yes, but as this was an ongoing investigation, that was the basis of my decision.
Well, before you made that finding, what kind of investigation did you conduct? What kind of zoning investigation did you conduct in order to reach the conclusion that this was a zoning violation?
Nothing beyond the information provided to me by the zoning administrator.
Okay. Now, furthermore, your office referred this matter to the zoning administrator for investigation, did it not?
My office, yes, I personally did not.
Okay, but John Bowman did, didn't he?
Yes.
Okay. And so you knew that the zoning administrator had the file in his, it's Jay Voigt is the zoning administrator, correct?
Yes, he is.
Okay, had the file in his office, correct?
Yes.
And what's Jay Voigt's job when he gets a complaint? We can get into the complaint thing at another forum, but what's he do?
Answer the questions.
I'm sorry, can you ask the question again?
What does Jay Voigt, as zoning administrator, do when he gets a complaint about an alleged zoning
I'm
violation?
again going to object to the relevance, but you can continue. Just for the record.
What's he do?
He opens the zoning investigation.
That's his job, right?
Yes.
And then he conducts an investigation, correct?
Yes,
And then if he concludes there is a zoning violation, he issues a notice of violation, correct?
that's correct.
All right, has he issued such one in this case?
As I believe you've stated, this is a separate issue, and so I don't have the time to go and look into every zoning violation that the county is processing, that Jay is processing. So I have not done any investigation into this specific zoning investigation, other than asking Jay if there has been any correspondence back with the property owner reaching out to try and address the notice of violation.
What'd he say?
He said no.
Do you know, so is your testimony you do not know if he's issued a notice of violation?
I believe, no, I can't say for sure if I know or not.
All right.
But I know that the investigation has been open and that the zoning administrator has reached out to the property owner to address the violation. And when I checked, I couldn't give you the date, when I asked whether any progress had been made towards addressing that violation, the answer was no.
We'll have other testimony, but I'll proffer to you, there has been no zoning violation issued, and furthermore, there has been communication with the zoning office about this matter. It may have been oral, because it was me, okay, right as soon as we got. Do you think the property owner just ignored this when he found out that his life, his livelihood was at stake here? Do you think he just, well, never mind. I'm sorry, I shouldn't have phrased it that way. Now, we're still on 155.004.
Okay.
Okay? You're finding that Shorty Coon failed to comply with this chapter, et cetera, or the rules or regulations of any other department or agency. By the way, you refer to the site plan section in this section, but really what you're referring to is the zoning ordinance in 158, aren't you? That's the violation. That's the alleged violation, is that you're not zoned for the use and you have the use on your property, therefore it's a zoning violation. That's the essence of the matter, isn't it?
But there's also the issue that development needs to follow the processes of 155, and that was not done. So that's also a violation.
So well, never mind. I'm not going to get into that. Okay. How do you reconcile the in connection with the preparation of any plans required under this chapter?
Can I ask the
Again,
relevance
I'm going to object to the relevance, but Chris, because you're on the stand, you have to answer. When it's my turn, we'll clean all this up.
Explain. You're citing that section as a defense of your actions. I'd like you to explain how that's relevant in connection with the preparation of any plans. I mean,
Is there a question there? What's the question?
how do you explain that based on the evidence and the variance application and the information you had regarding the contractor's equipment storage yard, how do you explain that you found that Shorty Coon violated a rules or regulation in connection with the preparation of any plans required under this chapter?
Because this chapter requires that when development occurs, Chapter 155 requires that it go through a process. What we have evidence of is a contractor's equipment storage yard that did not go through that process. So that is in violation of Chapter 155 and the requirement to prepare plans.
Well, in fact, 155 says if you're going to do a project, you
I'm
need
going to
to
object.
get a site plan,
This is
don't you?
testimony, not questioning.
All right, no problem, no problem. All right. Now, as you sit here today, excuse me if I've asked this already, are you testifying here that the contracts equipment storage yard had no influence or part of your decision to deny the variance?
No, I'm not saying that.
You're not saying that? Okay, well, how did it, what part did it play?
So if we, let's see. So per 150.33C, which is the legal requirement that they have to demonstrate that there's the reason for the variance, item number 3 states that they must demonstrate in sufficient detail that the variance request is not based on conditions or circumstances which are the result of actions by the applicant. In the original, or in the variance request, there were 3 items that they indicated were the reasons for the request: steep topography, the inability to have septic, and existing structures. So to address the existing structures, I stated in my letter that, let's see, and I'm reading from my findings. Regarding existing improvements, this includes an unpermitted contractor equipment storage yard, which should not be an impediment to the permitted residential development right. So essentially, saying that you can't build something through a regular process because you've got something unpermitted there, to me, is not, that's a hardship that you have put on yourself by developing something outside the regular process.
Now, why wasn't that a factor in the water resource conservation easement?
As I said, I'm treating these two different requests, variance requests, separate, and the water resources variance request was, when we look at water resources enforcement and code, we look at what's submitted on the plan, which was limited to the southern part of the property.
In fact, your real goal here in considering this forest conservation variance request was to force the property owner to clean up.
Objection.
I'm not finished yet. Was to force the property owner to clean up / address the contracts equipment storage yard, was it not?
Objection. The council can't know the state of mind of the witness in
He
what
can answer that wasn't his state of mind.
Well, I'm speaking right now in what he was thinking about as he was going through his decision on whether to grant or deny a variance. Council and the applicants have gotten a letter from the witness describing his thoughts and reasoning in denying the variance. So we can't go into the state of mind or what they were thinking. Mr. Schaefer has no way of knowing what Mr. Hine was thinking at the time, other than the letters that they received from the county laying out the reasons why the forest conservation easement was denied.
No, you finished?
I am.
Mr. Schaefer has a way of knowing or finding out, and he just asked the question of Mr. Hine. Did you or didn't you? He's under oath. That's the way I want to try to find out. Did you or did you not? You hear the question? Remember the
Can you
question?
repeat the question, please?
Did you or did you not really use your authority to deny or approve the forest conservation variance request as a means to try to achieve the cleanup / addressing of the contracts equipment storage yard?
No, this was not the motivation.
Okay. The fact that those letters are 4 or 5 days apart and you change your position and deny that doesn't indicate that
I'm
much?
sorry, which letters are you talking about?
Your letter saying, I won't consider your forest conservation variance request till you address the zoning violation. My letter saying, Chris, you can't do that. And 5 days later, your letter saying, okay, denied. Are you, based on that, you're saying under oath to this board that the cleanup of the forest or the contractor's equipment storage yard was not a goal or aim of yours?
Objection asked and answered.
I just repeated the question. He refused to answer. He objected to it. I then said, I have a way to find out. I can ask him what he did. Now, he can say no, or he can say yes, or he can say, I don't know.
I believe I answered the question. I said no.
No,
It was
okay.
not a motivating factor.
Okay.
There were
Well,
many
then-
factors that were taken into consideration regarding the variance, and those factors are outlined in my response and the findings. And the contractor's equipment storage yard is just one aspect of the many things that I responded to as a reason for the denial.
Okay, so what happened after the last hearing here when we tried to settle the case? Or tried to address the case?
So as I indicated before, I was kind of confused when I received the variance request because, as I stated, there were three primary arguments for the variance request. And why I was really confused is that the variance request stated that the property owner wished to be on the northern side of the property, but they couldn't because of three factors. Those factors were steep slopes, because of the inability for septic, and then the existing structures. And so I responded to those, but I was confused as to why those were factors, and we can show exhibits as to why I was confused.
No. What?
At the last hearing, and it was pointed out that the area which I don't know if it would help to bring up the exhibits, but the area that I viewed from my research had flatter slopes, so it was conducive to building a residence, and had soils that indicated that they would be well drained, that area was added to the subject property through an add-on. And there was a restriction in that add-on deed that said that no development could occur. And Mr. Schaefer indicated that they could not do any work in that area. So subsequently, I discussed it with the Bureau of Development Review, and they clarified that development could occur in that area if a plat was created for the entire property, and that's something that is done. And so that would take the restriction from development off of that area and would allow the property owner to put the off-conveyance in that area, which is what they wanted to do according to their original variance request.
So one of the reasons you denied the variance, forest conservation variance, was that you said that the property owner could use another portion of his land for the off-conveyance. Is that correct?
That's correct.
Right. And that area of the property happened to be where there looks to be some equipment and stuff located on, correct?
On a portion of it.
Yeah, one portion of it. Okay. Now, we then said, no, you can't because of this add-on deed, correct?
Correct.
And you said, well, okay, I'm 99% sure I'm going to grant the variance if that's true.
Yes.
And we said, good. And then you went back to your office and talked to Laura Matthias, correct?
That is correct.
Who's the person who works for you in development review, correct?
That's correct.
And she administers the subdivision regulations of Carroll County, correct?
Yes.
And she told you that if we did a thing called a special purpose plat, the property owner could put a building lot back there, right?
Yes, she did.
On the northern portion of the property. Could, okay, correct?
Mm-hmm.
Right. Now, what is a special purpose plat?
Again, my background is in civil engineering,
Okay.
and I do not have the land development expertise that my staff have. So David Beecraft from that bureau is here and can speak
Fair
specifically
enough.
to that.
Fair enough. But would you agree with me that your position would require the property owner to file a whole new set of applications and plans?
I am going to defer to David Beecraft on the mechanism, the specifics on obtaining a new plat. But my understanding is that it is not a lengthy process, and it's one that I believe you could speak to because I understand that you've taken projects through the special purpose plat process.
Okay. But, well, okay. But it's self-evident, is it not, Chris, that if you need to go to another area of your property and pursue development of it, you have to start a whole new process?
It would be a new process, but that would not be an unnecessary hardship, which is the criteria of the variance request.
Okay. And what is, do you know what that new process is, just in general?
Again, I would defer to David Becraft.
Okay. Well, let me just help you out a little bit, basically, because you get him later. You need to file application and new plans, correct?
I will defer to
Okay,
David
gotcha.
Becraft.
I'm going to object to
well,
this line of questioning, is what it has to do with an appeal of a forest conservation
It's the
variance.
I'm sorry.
Yeah, that was
It's
my objection.
He cited it as a reason he turned it down. That's the relevance. So then you then sent me an email describing that you had talked to Laura Matthias and that you found out we could do a special purpose plat, et cetera, correct?
So the email that I sent you was an effort to talk through a process that the property owner could potentially go through to if, and that's the if, they desired to put the off-conveyance on the southern part of the property. But again, the variance request, they indicated they would prefer that it be on the northern side of the property.
Let me show you a set of emails. Can you look through those? There's three of them there. Basically, I think there's three of them there, including including the email I have just referred to. And really, it's the last page, Chris, that I'm most interested in, but feel free to look through all of them.
No, I'm familiar with them.
Okay. And that is, I'd like to, what do I have enough copies? I've got enough copies. I'd like to offer this as my exhibit 7? 7. So that's a, one-page email. I don't know that we need to read it, but in that email, would you agree to me that you said, essentially, I would grant the variance if you went through the special purpose plat and cleaned up the contracts equipment storage yard?
It's a little more complex than that. So as I indicated, there were those three reasons why they requested the variance. And the one, and then the subsequent information that we received about the add-on. And so from my perspective, looking at the overall property and looking at that add-on portion where I feel that there's the potential for the off-conveyance to be put there and not have to get the variance request on the southern part, right? So what I indicated as a course of action that the property owner could go through is that if they went through the site plan process, which I don't know what the right term is, made it a permitted contractor's equipment storage yard, that site plan process may encumber a significant portion of that area that is, from a physical perspective, developable. And if that occurred, then they could submit another variance request, and there would be legitimate concern, or it would be legitimate that the encumbrance on that northern part was such that the only location remaining would be on the southern half. But that would require going through that process of bringing the contractor's equipment storage yard into compliance by going through the site plan process. So I offered that as a potential path for them to move forward through. But it does not have any relevance in my mind to the variance request. Again, their variance request stated that they would prefer to have the off-conveyance on the northern side, but they had these limitations. Those limitations do not exist, and so the variance could not be issued.
The last paragraph of that email, or the second to last, in the second sentence says, third sentence, however, the off-conveyance will not be approved until the site plan is approved and all legal documents recorded. So you may explicitly, did you not, make the cleanup of the contractor's equipment storage yard explicitly tied to the granting of the off-conveyance approval and variance?
I'm going to object to that question.
Can I ask a question?
I'm going to object to that question because what we are here for is an appeal of a denial of a forest conservation easement that was originally set for this hearing sometime in mid-November. There was additional information that was provided by the applicants on the day of that hearing that the county was unaware of, and then the county wanted to investigate that. So this case was continued to today. Any communications between the county and the applicants, or the county and the applicant's attorney, regarding the process, or the best process theoretically on how to bring this property into compliance, is irrelevant. It has no bearing on what we're here for, which is the appeal of the forest conservation easement. Anything that happens after, or any communications that occurred, between when this case was continued and today, has no bearing on Mr. Hines' original denial of the forest conservation variance request and the appellant's appeal of that denial.
I have a question.
Yes,
Chris, could you describe to me what the site plan process is?
sure, yeah, it's, I don't want to take all day with this.
Well, but that's what you recommended that they would go through to get clearance eventually for.
Yes, yeah,
Okay.
so site plan process is that, it starts with a pre-submittal conference and to discuss with staff what the project needs is to be. A development of concept plans to indicate conceptually what it is that they want to construct. Once concept approvals are achieved, then it goes to Planning Commission for a concept review. Then final plans are produced, and then once the final plans are approved, then it goes to Planning Commission, or potentially the chair of the Planning Commission for final approval. And then there are final plans produced, and construction can occur for any improvements that are necessary.
This sounds like a very long process. How long would it take them to go through this, like 6
It
months?
typically takes about a year.
A year, yeah, okay.
I'm going to advise the board at this point that settlement negotiations, that's typically not something that ever is comes into evidence. So they may occur, but the body deciding a matter doesn't usually find out what happened in settlement negotiations.
Well, are you telling me you're not going to admit my exhibit?
No, it's admitted.
Oh, okay.
I'm just telling the
Okay,
board that
gotcha.
settlement negotiations
Gotcha.
typically, nothing about them come into evidence.
Got it. May I continue with him?
Sure.
Are you okay? I'm going to address that in a moment. Chris, really, the process would be that you recommended or asked, required, or whatever, would be that the applicant would need to file a conditional use request to the Board of Zoning Appeals of Carroll County for a contractor's equipment storage yard, correct?
I again want to state for the record my objection to this entire line of questioning.
Are you objecting to Mr. Barrett's question? I mean, I'm just following
I'm
up.
objecting to your question. I'm not objecting to Mr. Barrett's question. I'm objecting to your question.
I think I'm entitled, if we're going to have testimony about the process, I'd like to have the testimony be accurate about the process. And that's why I'm asking the question.
Okay, that's fine. I just want it for the record. I mean, you're taking attendance and putting that on the record.
Okay, that's fine. So he would need to file a conditional use application to the Carroll County Board of Zoning Appeals, correct?
That is correct.
And that's a board like this, well, it's a board with quasi-judicial powers, correct?
That's correct.
There's application fees and a process, correct?
Yes, but that process is not an undue hardship.
Okay. I'm not conceding that, but that's not the question. So that takes 2, 3, 4 months, right?
I don't.
You don't know?
I can't.
If you don't know, you don't know. Okay. And there's cost to it, correct?
Yes,
And the board sends notices to all the neighbors, et cetera, right?
Yes,
And then you have a public hearing like this one, correct?
yes,
And then within 30 days, the board renders a written decision granting or denying your conditional use, right?
yes,
And then you start the site plan process, right?
yes,
And I think your site plan was a good general summary, but I just want to ask one question about it. During the site plan review process, do all the county agencies, and plus the State Highway Administration, plus the Carroll County Health Department, do they review the site plan?
yeah, all the applicable agencies. In this case, because State Highway isn't anywhere near it, State Highway would not review it.
Okay. But, for instance, it would get a water resource conservation review, would it not?
Yes, it would.
It would get a sediment control review, right?
Yes, it
Do
would.
those take time?
Yes, I do.
Okay. And there could, now, as you sit here today, having ascertained, in your opinion, that the developer or that the owner could get a lot or a conditional use approval for kind of on that northern portion of the property, right? You think that's your recommendation, that he pursue that, correct?
That was the indication in the variance request, that that's what the property owner wished.
Okay, okay. But you don't know, as you sit here today, whether he could achieve either of those ends, do you? Both ends being single-family lot or contractor's equipment storage yard. You don't know if he could meet all the requirements, do you?
I don't, but I believe the burden is on them to provide that in the variance request for me to make a determination on.
So, if you get a variance request, I got a 100-acre farm, and I want to take a 1 acre off conveyance to sell. Now, you get that, and I need a variance from the Forest Conservation Ordinance, let's say, okay? Do you then look at my whole farm and see if there's any place else on it I could put that 1 acre lot without needing a forest conservation variance?
I'm just going to object for the record. This is a hypothetical. But you can.
It's a hypothetical
you can
because it
answer.
illustrates the fact, I'll proffer to you, that it illustrates the fact that that is not the analytical method that is employed in hardly any reviews of zoning, of water resource or of forest conservation variances. And if it were, it would be ridiculous, wouldn't it? Wouldn't it, Chris?
No.
Again, I'm objecting. That's testimony. That's not a question.
Well, do you commonly use as an analytical technique when you're reviewing a variance, an environmental variance, do you look at the whole parent tract? We call it the parent tract, the bigger piece that the owner owns, and they're kind of cut a piece off. Do you look at the parent tract and say, I Google, like you did here, I Google Earthed it, it looks like I looked at the soil types, I think you could probably get some perks up there, I'm not sure, but, do you do that in your typical variance case?
Yes, working through staff, we do.
Oh, you do?
Yes.
And you tell people, sorry, I'm not going to approve your variance, you got to go, you can do it over here, go investigate that piece of ground? You tell them that?
Again, I have processed 4 or 5 thereabouts of those. This is a hypothetical. I would need to look at the specifics.
Bear with me 1 second, please. Do you, well, I'll strike that. The forest conservation variance request and the water resource conservation variance request were both filed on February 22nd, 2022. We're now December 9, 2022, or I think it's the 9th. Yeah, it is. Why wasn't this being, hey, why don't you look at another piece of ground, brought up sometime prior to when you denied the variance?
So again, speaking to process, staff works with the property owner to gain all the information so I can make an informed decision. I received the variance request package on June 15th. In my review of it, I did look at the forest conservation variance request. I did look at the entire property, and as I've indicated, I was confused about the request, because again, the request was steep slopes, which we will show that the slopes are flatter in the area that we're talking about. Septic, which again, the soils indicate that septic should work, and other features that were there. So I did look at that specifically as part of my review, is that because fundamentally what they're asking for is, they're saying, we'd like to put it on the north side, but we can't because of these issues. So we want to put it on the south side, which then requires this variance to the forest conservation easement. And when I looked at the north side, their arguments did not hold water because of what we've discussed today. So that's why I denied the variance.
Chris, they really didn't say that, did they? We wanted to put it on the north side, but we can't. They didn't say that, did they? They said there were other buildings or structures that existed on the property, but they didn't say we wanted to put it on the north side, did they?
Yes, they did. So if you refer to the variance request from RTF, middle of the second paragraph, it states, ideally, the lot would use the existing driveway entrance and access location on the north side of Morgan Run, make it a much more cost-effective option. And then they reiterate that at the end of the first paragraph on the second page. It says, as mentioned earlier, it would have been more cost-effective and efficient had the off-conveyance been able to be placed on the north side of Morgan Run.
What's the date of that letter?
This is May 18th, 2022. This was the variance request submitted to my office.
Okay, I got the letter. What part were you reading there?
Okay, I'll go back. So
Ideally, where's the ideally?
second paragraph, was it 6 lines up from the bottom? It says, ideally, the lot would use the existing driveway entrance and access located on the north side of Morgan Run, making it a much more cost-effective option. And then it goes into, it was deemed not possible due to those 3 items that we've talked about. And then it reiterates that statement at the end of the paragraph on the second page, which says, as mentioned earlier, it would have been more cost-effective and efficient had the off-conveyance been able to be placed on the north side of Morgan Run. So I think my interpretation of that was they wanted it to be on the north side of Morgan Run. But they couldn't because of those factors. Those factors have not borne out, so that's why I'm not sure why we're here, because my interpretation of this request was that they wanted to be on the north side.
Well, then, why did you say, when you reviewed the water resource confirmation, that due to the nature of existing site, there are no alternative feasible options for the proposed development on the proposed lot?
Again, we're talking about 2 different applications here.
Well, but we're talking about the same property, aren't we?
Again, when looking at the Water Resources Code and looking at, and so on, you look at what is submitted on the plan that is before us.
Okay, did you also say in your water resources
We're not here for the
decision
Water
that?
Resources Code.
Objection is relevance, also asked and answered.
No, it's not asked and answered, but, and it is relevant, and it's relevant for the reasons I've laid out before, is that when an administrative agency administers its regulations, it has a duty to treat similar cases similarly. It's fairness to the property owner and the applicant. And that's why it's relevant. It's also relevant because the same rationale that he's, well, a different rationale. Okay, well, I'll leave that alone for now, okay? I do want to say that this is Exhibit 6. I'm showing page 1 of Exhibit 6. You know what that is?
Could you identify it for the record, Mr. Schaefer?
Yeah, it's a exhibit plat of the proposed and existing forest conservation easement for the Coon property. John, if I got the right one, is this the one?
I'm gonna clean all this up, don't worry.
Okay, look at page 2, I'm sorry. The same drawing, just a different type. That, Chris, is that the exhibit that shows the water resource protection easement your department required / negotiated / accepted from the property owner as part of the variance request for water resource conservation?
It looks like it. I'm not familiar with it.
You have that up there. This shows a water resource, this is the lot. No, the lot's this, okay? The lot's this, that we want to create. This white area is the billable, has been determined to be the billable area after environmental reviews, okay? So there was discussions that ensued, and the result was that the entire undisturbed area was required to be put in a water resource conservation and forest conservation easement. They kind of just doubled up on it because there's some forest in that area too. And anyway, I just wanted you to see that that's already part of the requirements. And that area is about 2.632 acres, and it's in that easement, correct? Do you know?
I do not know.
Okay. Now, you granted that easement, correct? The water resource conservation easement?
Yes, but we're not here discussing that easement.
Well, I will let Mr. Ullman do that, but did that water resource protection easement provide an environmental benefit or enhancement?
You can answer.
Yes.
Okay? And in fact, if you look at your Bible, the variance definition in your code, is one of the criteria, look at A3.
What, is this under 15033?
50.33.
That's for forest conservation variance appeals. The water resource management has its own variance section.
Can we?
I mean,
I'm
it's
aware of
probably
that.
in your book.
I'm aware of that, Jim. but
Okay.
Can we look at A3?
Sure. And we're looking at everything else.
Do you have a copy of that?
I can find it, yes.
Thank you. 150.33A3, okay.
What's that say?
It can be proven that some action associated with the project will result in measurable environmental enhancement that can be equated to the estimated benefit which would have achieved if the technical requirement that the applicant is requesting relief from would have been accomplished.
Okay?
Okay?
And you just testified that the water resource conservation easement provided an environmental benefit or enhancement, did you not?
Yes?
Okay? So why wasn't that? And I note, by the way, that the 4 criteria listed under A are in the, I just saw a cartoon on this, the disjunctive. It's the word or is used, not and, meaning that any one of those 4 can be the basis for a variance. So why wasn't that, why didn't that equal a grant of a variance?
Again, I'm going to object for relevance, but Chris, you can answer.
Yeah, so pursuant to 150.33C, the applicant must submit a written request for variance which meets, and then there are 5 requirements. And so that's what I review a variance request related to.
Well, do you think, listen, we're here today, we're at de novo. Do you think that that there's an action associated with the project that would meet that criteria?
Where is it again?
I mean, and again, we're getting back to the estimated benefit. We talked about that earlier in terms of 08 versus 08 Forest Bank. So you said that you thought there was a net benefit, right?
Right, and so this allows that they can apply for a variance, right? And then they were required to meet the 5 criteria for a variance to be issued. And what I've determined is they did not meet all 5 criteria. So that's why the variance was denied. That
Did
was
you-
clearly in my findings.
Okay, so I mean, the answer is no, Clark. I do not believe that there's an action associated with the project that meets 3, right?
No, a variance request must meet those 5 criteria in order for me to be able to issue the variance, which they did not achieve.
Okay, well, that's a semantic difference. I mean, it says
Indifference.
it says the county may grant a variance.
May.
Oh, may, you mean you can turn it down for any reason?
Objection, that
No, that's an
accusatory.
answer, that's a question. You said may.
All right, continue.
Well, I'll continue. Does that mean, in your opinion, you can turn it down for any reason?
It means that I have a prescribed code which tells me what I need to review the variance request against to determine if they meet all of those criteria, and that's what would allow me to issue the variance. In this case, they did not meet all 5 of the criteria, which was outlined in my findings, and so I could not issue the variance.
Okay. Are you refusing just to answer my question of whether or not you think the enhancement associated with a water resource easement is a benefit that can be equated to the estimated benefit of the 08 acres being left, a driveway being put over .08 acres?
If I may, I'll point out that number 4 of the 5 criteria states, demonstrate in sufficient detail that the variance does not arise from a condition relating to, no, I'm sorry, that was the wrong one. Number 5, demonstrate in sufficient detail that the granting of a variance will not adversely affect water quality or result in an environmental degradation condition on or off-site. And my response to that was, the applicant has stated that the proposed preservation and mitigation are sufficient to offset the proposed environmental impact of releasing the forest conservation easement. So I did not have an issue with that. However, there were 2 other items, which we've already talked about, items number 1, number 3, which they did not meet, which is why I had to deny the variance.
Okay. So if Mr. Kuhn complied with the forest conservation ordinance, meaning no variance, okay? Do you agree he would then be forced, in order to exercise his off-conveyance rights, to attempt to relocate the off-conveyance to the northern portion of the property as you refer to it?
No.
Okay? What would he, where could he, you've analyzed where he could move the off-conveyance to. Well, wouldn't he, if he wanted, well, let me back up. Does Mr. Kuhn appear to have off-conveyance rights to this property? This 1 acre
Yes.
he's eligible for it?
To my knowledge, yes.
Yeah, I mean, he's 8-10 months into the process. Okay, so he's eligible for an off-conveyance. He owns a property that's eligible for an off-conveyance, correct?
Yes.
All right. He wants to put it here, right? Where we applied for it. He wanted to put it there, right?
That's where he applied for it, yes, but that
He
wasn't.
didn't really
the
want
location.
to. He really wanted to put it elsewhere, is your testimony.
Correct.
Which I disagree with. But he applied to put it here, right?
Yes.
Okay? And you're telling him you don't want him to put it, you won't give him a variance to allow him to put it there because he can put it somewhere else. Doesn't that equal that he would be forced to relocate his off-conveyance if you don't give this variance?
No, there are a lot of constraints when you're going through a development process. He could propose to put the off-conveyance in the middle of Morgan Run, but there are physical constraints there. In this case, there's a legal constraint, which is the existing easement, which county code says cannot be released, and that is a constraint that the developer needs to work through. And because there is a viable option, one that they indicated that they would prefer because it was cheaper, that to me is a viable option, a reason not to not to allow the variance of releasing that easement.
I'm going to try one more time. If the property owner is not allowed to put the off conveyance where he applied for it, do you agree with me that he would have to relocate it to another place on his property? Or try to relocate it?
Yeah, if he's not allowed to put it in one location, he would have to put it in another. Yes.
And if he did that, and you in fact specifically identified a place where you thought he could put it, right, or should put it, right? The northern portion of the property,
Yes.
right, okay? And you Google Earthed it and looked at the soil types and stuff like that, right?
Correct.
Okay. Now, if he did that, he would then need to go through, I'm not going to get into the special purpose plat, et cetera, right?
Yes.
Okay, and that would involve addressing the water resource conservation ordinance, the
Yes.
forest conservation easement?
Yes.
The stormwater regulations?
Yes.
Health department regulations?
Yes.
Et cetera, correct?
Yes, but those are not hardships.
Just a minute, Chris. Well, you can say that, go ahead. If he did that, he would do that for the purpose of locating a single-family house on a 1 acre lot, correct? Or about a minimum of 1 acre lot, right?
No. What,
Strike that. If he did that, he would be doing it for the purpose of getting eligibility for a building permit for a single-family residential structure, correct?
yes.
Okay. And if that occurred, and if he got all his approvals, and if there weren't environmental constraints that prevented him from using that land, if and the health department, the perks worked, and it all worked, and the site distance was okay, and all that good stuff, he would then build a house there, or be eligible to build a house there, right?
Yes.
Right. Do you believe that would result in an environmentally degraded condition on the northern portion of the property?
No. If you meet all applicable codes, then it would not.
It wouldn't. You don't think putting a single-family house on a vacant piece of ground infects the environment?
So we're getting into semantics then, as far as allowable impacts and impacts. So yes, there would be a theoretical environmental impact, but it's allowable through addressing the appropriate county and state and federal codes.
Now, I'm specifically referring to 150.33C1, and you like the C section of that code, so let's talk about C1. You don't like the A section, but you like the C section. What's C1 say?
C1 states, describe the special conditions or exceptional circumstances peculiar to the property which would cause the undue hardship or that prevent the applicant from complying with the subchapter with on-site or off-site mitigation and evidence that compliance would result in an environmentally degraded condition on or off-site.
Okay, so you understand that we just talked about whether, I'm not going to go over it again, but whether or not that moving it to another place is going to involve development on another portion of the property, right?
Correct.
Okay, and I mean, let's be honest, well, not honest, I mean, I am honest, but, this, and when somebody tells you they're honest, you better watch out. This is an environmentally tough site, isn't it, Chris? It's got Morgan Run running through it, doesn't it?
Yes, it is.
So any development on this site is going to have environmental challenges, isn't it?
Yes,
Yeah. They all do, don't they?
they all do.
Yeah. All right. Now, can you look at, well, you've got that 150.33E, capital E.
Yes.
Okay. Did you provide that notice to the Maryland Department of Natural Resources within 15 days of the receipt of the request for the variances?
So when I process the variance request, I then provide it to Mr. Bowman, and Mr. Bowman addresses that.
Do you know if he did it or not?
I do not know.
Okay. Do you know if DNR sent in an objection or to this variance request?
I am not aware of any.
Okay. If you were aware of one, you would have cited it in your decision, were you not? Would you have not?
Yes.
Okay. All right. I'm almost finished with him. May I request a 5-minute recess?
I, no objection.
Thank you.
I need to run to the bathroom.
Okay.
I am almost finished, but I have a couple more questions. Mr. Hine, does your file reflect that this off-conveyance approval, or this off-conveyance application has received all necessary approvals except for forest conservation?
I do not have a file to that effect.
Okay. Okay, well, we'll put that on another evidence, but if this were, well, never mind, done. Now, do you know, have you ever met the members of the Board of Appeals?
Yes, I have.
Okay, what was the occasion?
We had another appeal hearing, when was that?
In July?
July, thereabouts?
Okay.
That was the pool one,
Do
right?
you know them from them being on the members of the Environmental Advisory Council?
Yes. that-
Objection. But you can,
Well, sorry.
you can answer. I'm just objecting for the record.
Yeah, so, yes, the Board of County Commissioners have appointed them to the Environmental Advisory Commission, which is, it's advisory to the county commissioners. The appeal process, in this case, it is up to the county commissioners whether they want to hear it or appoint a committee. And in the two previous examples of an appeal of this sort, we have relied on the volunteers from the EAC to preside as the board for these types of hearings.
And in fact, your department staffs the Environmental Advisory Committee, does it not?
Yes, one of my employees is the employee representative that works with the EAC.
Do you ever appear in front of the EAC?
Oh, I've presented and talked once or twice, yes.
Okay. And you haven't talked to anybody on this panel about this case prior to
No,
today, have
absolutely
you?
not.
Okay, thank you. That's all I have.
Any cross?
Well, I just, a point of order. So, Mr. Hine is my only witness. So I was just wondering if I could just put on my whole case now while he's on the stand.
And I have no objection to that.
Just out of interest of time. And because I'm doing it that way, I would be happy to give the floor to any of the board members who want to ask Mr. Hine questions of his testimony regarding the questions from Mr. Schaefer.
Okay, go ahead.
So they can ask questions.
Well, the only thing, as soon as that map arrives, wherever it is, I'd like to take another look at it.
Absolutely.
Well, we can, I mean.
Yeah,
I don't
that's
mind.
coming up in my
Okay.
case.
So you can ask questions now, or you can ask questions after the end of his presentation with Mr. Hines. So either one you could do.
Well, why don't you introduce it for identification, and if he wants to, I mean, maybe you
It's
don't.
coming. It's coming,
Okay,
Clark.
gotcha. I don't want to force you. Okay.
Okay. Okay, Mr. Hine, thank you. Several questions you've already answered. So as, Mr. Hine, as you've stated that in your position as Director of Land and Resource Management, you have experience with forest conservation easements, is that correct?
That's correct.
And are you familiar with the property located at 3033 Salem Bottom Road?
Yes, I am.
Okay. I have what is an aerial picture.
Yes.
To the best of your knowledge, is this a fair and accurate depiction of the property located?
Yes, it is.
Salem Bottom Road? I would like to introduce this as Exhibit 1. So I'm just going to keep this here for now.
Can I see that a little closer up? Does that come off that board?
It does.
Okay, good.
Yeah, and I have, Clark for you.
You have a paper copy for me, Glenn?
I do. Give me 1 second
Would you like this? Is this okay?
That's good.
to find it. I have it somewhere, I swear.
Thank you.
Okay. Now, on, why don't we just go up with the map? So, because we're gonna be pointing things out, and Clark, you can have,
John, will you walk up with me?
I was gonna suggest that, or I'd go over there.
whatever you want.
Shorty and Cody, why don't you walk up too? You know the property better than anybody.
Can you all see that then?
Yeah. Perfect.
We all around. Chris, can you please, actually, is there a forest conservation easement on the property?
Yes, there is.
And can you point out where it is?
Yes, it's this green area here.
Okay, so for the record, it's that green sort of triangular area on the map?
Yes.
Okay, and what is the purpose of a forest conservation easement?
It's to preserve environmentally sensitive areas, in this case related to forest.
Mm-hmm. And did the owners request a variance from the forest conservation easement?
Yes, they did.
Okay, and specifically, they requested relief from the policy protecting what are known as priority one trees?
That's correct.
Okay, which is not allowed.
Correct.
And what is a priority one forest?
It's I will go off of memory. Again, this is not my area of expertise, and Mr. Bowman could speak to it more specifically, but to my remembering, it is forested areas that, due to steep slopes or water resources, are a higher priority than other forests. So that's the designation of what creates a priority one forest.
And the applicants submitted a variance request, is that correct?
Yes.
I'm gonna be coming up with my exhibit 2.
Again, so just for reference, this is Morgan Run through here. It's not obvious. This is the north side that we're talking about, and this is the south side over here.
Hey, Chris,
Yes.
you gotta wait for Jim to get back.
Oh, I'm sorry.
Because it's not fair.
Understood.
I need to hear what you say to him.
Well, I did want to.
Well, I know.
I was just pointing
honest.
features.
Apparently, there's only one of us.
No, I answered honestly.
So, Mr. Hines, so you just testified that you received a variance request for this, for the forest conservation?
Yes.
Okay, is this a fair and accurate depiction of the letter you received?
Is that the one dated March or May? Yes.
Okay, and where'd Clark go?
We're here.
And that's in one of your
it's in
exhibits,
one
I
of my
think it's like
exhibits.
your exhibit 5 or
That's fine.
something.
I'll take it though, if you got
Okay.
time.
Mhm.
Are they free?
Yeah, oh yeah, they're free.
Okay.
I would just like to introduce this, exhibit 2
No objection.
into evidence. There we
Alright.
go. Okay. I apologize as I'm getting organized. All right. So, Mr. Hine, and I know we've already done this, but I think it's very important to reiterate. Can you please read the highlighted section on Exhibit 2?
Sure. It says, the location of the off-conveyance lot was not just haphazardly chosen. Ideally, the lot would use the existing driveway entrance and access located on the north side of Morgan Run, making it a much more cost-effective option. It was deemed not possible due to steep slopes, existing improvements, and associated well and septic area. Do you want me to continue?
Yes.
Additionally, the owner developer is a contractor by trade who performs perk tests and installs septic systems, and it was determined that any usable ground on the north side of Morgan Run would not support a sewage disposal area, just a potential septic system. Replacement area for the existing house. Let's skip to here. Therefore, the only area that supported a sewage disposal area is the approved perk-tested area on the south side of Morgan Run. These reasons, which are not based on conditions or circumstances, which are the result of actions by the applicant, are why the owner is requesting a variance to remove a minimal area of easement. As mentioned earlier, it would have been more cost-effective and efficient had the off-conveyance been able to be placed on the north side of Morgan Run.
Again, this is the variance request.
Yes.
Okay, and so can you just point to what we sort of have been colloquially referring to as the north side of the property?
Yes, so we've used Morgan Run as the defining line. So this is the north side of Morgan Run, this is the south side of Morgan Run.
Okay.
More accurately, the north arrow would be like this, would it not, on
Correct.
this aerial?
Yes.
So
Yeah,
can I ask a
there's
question?
one arrow here.
So this is the conservation
That's the easement, yes.
easement, and this says, is this the proposed?
Well,
Is
that
this
might be my next. Where is
Okay.
the proposed off-conveyance lot? You're getting ahead of me. Off-conveyance lot.
It's in this area, on the
Okay.
south side of the property.
Mhm.
It's this.
Yeah,
Like this.
that's what I was looking
Okay.
at.
Yeah.
And in order to get to, and well, for the proposed off conveyance, they want to build a residential lot, is that correct?
That's correct.
Okay. And to support that residential lot, do the applicants want to build a driveway to that lot?
Yes.
And where are they proposing to build that driveway?
Maybe John can point to the very
Yeah, that would be-
specific location, since it's not shown on here, but generally it would have to go through the protected easement.
Generally speaking.
Which is why we're here today.
Which is why we're here.
Yeah.
Yes.
Yeah, small strip, gonna go right through a sliver here.
Can I ask a question now?
Absolutely.
So if they built a driveway on the northern portion, would the house also be located on the northern portion, or would they have to cross Morgan Run with the driveway?
That- Can I answer?
Yeah, you
So that's entirely up to the property owner, where they want to build it,
Okay,
how they want to access it, and so on. They just have to conform to the appropriate codes. So if they wanted to build over here, but build a bridge across the Morgan Run, and they went through all the appropriate
Yeah.
requirements, they certainly could do that.
All right, Mr. Hines. So again, when
One other
you,
question, can I, before?
Yes.
So this is proposed, easement?
No, this easement is an existing easement.
No, but this is proposed, according to this map. Proposed what is it, where is this?
So that area is, maybe John can point to it. So as part of the off conveyance, and please correct me if I misspeak, as part of the proposed off conveyance here, they were going to put additional area into easement. Did I accurately?
That's correct.
Okay.
I can answer that one.
Yeah, I just want to make sure I'm not.
Okay.
And not only going to, but we're required to do so in order to achieve a water resource conservation.
When
variance.
would this become, what does it take to go from proposed forest conservation to an easement? That's a legal process?
Yeah,
Yes.
you execute an easement, sign it, and then it's recorded as a condition of the off-conveyance approval. The way the system works is, it's all based on building permits. And you can't get a building permit till you get off-conveyance approval, and you can't get off-conveyance approval till you deliver all the documents you promised you were gonna deliver,
Okay.
including these easements.
Okay.
does anyone know why this particular strip is part of the easement and say this part isn't?
We do.
Or,
Do you want to explain or?
Yeah,
I'd
we
be happy
do.
to.
And the Shorty Coon's testimony will be, he bought this piece as an add-on piece 5 years ago. No, that's okay. And he didn't know when he bought it, I think he paid $15,000 for it from a neighbor, okay? He thought he was buying access to where he wanted to put his off-conveyance line. He didn't know it had a forest conservation easement on it. His fault. It was recorded in the land records, there was an easement on it, okay? But he didn't find out about that, and again, his fault, he should have known, until this came up, and John Lemmerman said it.
Yeah,
And then when he found out about it, he said, well, we gotta ask for a variance.
yeah.
And
Okay.
that's where we are.
but what's special about this triangle that's not special about this area?
So this is an existing easement, so it was created as part of the development that occurred over here.
Okay,
So this previous development had to put the property into easement. This also is an easement on this side as part of that development. And that property extended onto this side
Okay.
of Salem Bottom. And so then, as Mr. Schaefer just indicated, this property over here was sold to the Coons
Okay.
with the easement already in place.
right.
The easements that are shown here are proposed easements as part of the off-conveyance development process.
Okay.
It just seems strange that this is disconnected. I mean, this is all part of, really?
Yeah, so, yeah,
Yeah.
this parcel extended onto this side of Salem Bottom Road. And when they developed it, they had a requirement to put so much property into easement. And because it was over here and they really couldn't do any development as part of what they were doing here,
Yeah.
that was an obvious place to put it.
Okay.
As well as, it's a priority 1 forest, so that's the type of forest that we would prioritize in wanting to preserve.
Okay.
So that driveway would go through the proposed easement area also?
Yes, it
right?
would.
You'll go right
Right.
through, sort of the middle. We're gonna show you photos, and sketch, but yeah, right through here.
Where would the lot be for the house?
You can see,
Where would the house be?
John, can you point it?
So see that corner there?
Is this
I believe
it?
it's that corner.
Yeah, that's the lot, sir, so this triangle piece.
This is
that
John
little-
Yeah.
Lemmerman speaking. He's my witness. He's a surveyor from RTF. Go ahead, John.
Okay, thank you.
And speak up so that Megs will pick you up, please.
All right, so this triangle here on this exhibit
Yeah.
plat is the easement
Yeah.
area, so the lot sits like right here. So there's gonna be a small sliver about right here, just wide enough to get access through, is
Mhm.
all that the
Mhm.
applicant is asking you to do for access. Which you can see, which would be this little rectangle there.
And Meg, I don't know, I detect this was a question, but if it's not, I apologize, but it is somewhat unusual as, I think.
Clark, are you testifying? This is my,
I'll shut up,
Examination.
I'll shut up, trying to explain it, but
you can,
I was
you
allowed
can
to
explain it when
earlier.
it's your turn. So, just to reiterate, in the variance request, that they said that it would be more cost-effective to have the off conveyance on the northern side, correct?
Yes, because on the northern side, as you can see here, they've got an existing driveway
Mhm.
back to an existing residence.
Right.
And so the costs and so on associated with getting the driveway and so on, that's already in place.
And that driveway wouldn't be going through any forest conservation
Correct, yeah,
easements.
yeah.
They also said that not deemed possible due to steep slopes and existing improvements as well as septic area.
That's correct.
So essentially, it's your understanding when you read this that the northern part of the property, for lack of a better term, just can't handle the residential lot from the off conveyance, which is why they requested to put the off conveyance on the southern side.
Yes.
Okay.
I don't understand those words.
So,
Yeah, could you
Yeah, sure.
elaborate?
yeah, absolutely. And do you want to grab the next exhibit?
Yes.
With that?
Mm-hmm.
We'll step you through each of those statements and what they,
Yeah.
Which one is the residence on the northern side?
I believe, and correct me if I'm wrong, this is the residence down here?
Yeah, this is where we live right
Okay.
here.
Okay.
There's-
Okay, I would like to introduce into Exhibit 3, a map of the same property, 3033 Salem Bottom Road, with contour lines that detail the steepness of the slopes on the property.
No objection.
As Exhibit 3, yes, Exhibit 3.
I'm calling it opposition exhibit 3.
Opposition Exhibit 3.
Okay.
Mhm. Now, Mr. Hine, can you just, for the record and for the board, explain the difference between, or what these contour lines mean and the difference in the width
Sure.
of the lines?
Yeah. So if you're not familiar, contour lines indicate lines of equal elevation, right? So everywhere along a single line is the same elevation. And steepness would be indicated by how close or far apart those lines are. So if lines are very close together, it's very steep. If they're far apart, it's relatively flat in comparison to the steepness. And so in the variance request, it indicated that they couldn't, despite wanting to, they couldn't put it over here because it was steeper here than here. And when I looked at that, to validate that, I looked at the contours here, related to the contours over here. And this, to me, is a much flatter area.
Flatter.
So I don't see how that argument stood the test of looking at the physical properties of the,
Except do we know if there's any other issues putting a house there? Because that's where the house would have to go then, right? So there may be other issues.
exactly.
But you don't know about,
But
and
I
they
don't
don't.
know, I
Yeah.
had to go based on what the evidence that was
Mhm.
provided to me.
Now, this is from a LiDAR map,
Yes.
LiDAR data. Can you just explain to the board what
Sure,
LiDAR
sure.
data means?
Yeah, so LiDAR data is produced by an airplane flying over. It has a laser that scans. It takes those returns and it basically creates billions of points.
Yep.
And then those points can be turned into a contour map because those points have elevation information.
Yep.
Amazing.
Yes,
It's very expensive, but very accurate.
yes, yes, it is.
Is that what they call flown topography?
Yes.
You can do that in drones, you can do that in aircraft,
Mhm.
yeah.
It's my understanding it's an aircraft, right?
Yes.
Yeah, they're saying this is not steep enough that it would be a hindrance. Or is it more like up in this area where it gets a little flatter?
Yeah, so that's what they're proposing as far as the off conveyance, is putting it up in this flatter
in that
area.
flatter
It
top
still is
part,
going to be
yeah,
a torturous
okay.
site to try and build on, but that's, we don't, evaluate on that, we evaluate on what the code says.
Okay. The request for the variance also, provided that, there were existing improvements on the northern side of the property, that I guess prohibited, an off-conveyance residential lot from going on the northern side. Can you point out those existing improvements, please?
Yeah, so based on the aerial, I'm just looking at the developed type areas, and so there's the existing house and then some outbuildings and so on. And this area here is what Mr. Schaefer has been discussing, which is what our zoning administrator has determined is a unpermitted contractor's equipment storage area.
That's not accurate.
Okay,
How is,
There's been no determination by the zoning administrator on this matter.
okay, I withdraw the
You-
statement, it's
Okay.
semantics, it's,
Mr. Hine, would you say that this just grouping of material and buildings is an improvement on the property?
yes, it is.
Can I ask a question?
Yes.
So you wouldn't put it there, your lot, I mean, you wouldn't prefer to put your house there because it's not as, it's not as beautiful a place as this. It's obviously, this is gonna be a lot better for the house, prettier.
Preferred location.
Yeah,
The
I mean,
owner's preferred
that makes all the
location.
sense to me, in that this is more beautiful a location for the lot versus over there, which all these structures in there. So there is some issues. Okay.
Yes, sir.
So, excuse me. Indulgence, please.
With the soils map.
Not yet. Not yet.
Aesthetics, that's the word I was trying to think of, aesthetics. Aesthetics are much better.
Yeah.
Southern side.
Is that, while we're in pause, is that a man-made pond?
Yes. Interesting fact, there are no natural ponds in the state of Maryland.
Really?
Yes, there, yep,
They're all
all
farm
man-made.
ponds, yeah.
Yep,
No lakes, no ponds.
yeah, we're too far south and we didn't have glacial action that created
Yeah.
natural ponds and lakes.
Or reservoirs and.
No natural lakes in the state of Maryland.
No,
Deep Creek's not natural.
no,
Mr. Hine,
yes,
was any evidence in regard to this variance request provided to you regarding, that the ground is not suited, the ground on the northern part of the property is not suitable for development because of, it wouldn't support a sewage disposal area?
the statement was made sort of qualitatively that because the property owner is in the business, that they did not feel that there was any suitable area, but there was no perk test, no quantitative information related to the north side of the property.
So it's fair to say they made a claim,
Correct,
they did not provide any evidence to back up that claim.
correct.
Now, for septic systems, is the type of soil important to the approval of a septic system?
Yes, because you, the septic system is looking to drain the liquids off into the ground.
Is it fair to say that the type of soil would be determinative on whether or not a septic system can be installed?
Yes.
At a property?
Objection. And the objection is, he's not an expert in that area. And I don't know how he can testify as to unless he is, septic systems and soils and how you get them in.
Professional engineer
Yeah.
registered in the state of Maryland.
I know you are.
Okay.
So, your objection's noted. I would like to introduce,
One other question.
yes, for sure.
Is the permeability, could you put a well in there? And is that an issue?
We're getting to that.
Okay.
Does this house have a septic system? Does anyone know? I assume it does,
I
but
believe it
Yeah,
does.
that's-
does,
existing?
does the existing residence have a septic system?
Yes.
Okay.
Yes.
I'd like to introduce as Respondents Exhibit 4, a map of the same property, 3033 Salem Bottom Road. It's a hydraulic soil group map. Again, the same property, just with a different overlay.
That's right.
Don't mess with the gavel.
I didn't touch the gavel.
So, can you explain to the board what the different colors on this
Sure.
map represent?
Yeah, so this is a hydrologic soil group mapping, and it's produced by NRCS, which is National Resource Conservation Service.
And are they part of the United States Department of Agriculture?
Yes, yes, they are. Yep. And so the colors represent, the hydrologic soil groups are grouped into 4 categories, A, B, C, and D. And they kind of generally describe characteristics of those soils. The primary one being how well drained, how infiltratable they are. And so an A soil and is the most, it can infiltrate the best, a D soil the least. And as you can see from the legend, most of the predominance of the property is hydrologic soil type B, which would indicate that it is well drained. Down through here where the pond is, that because of the pond and so on, that's D, and then where the stream channel, that's type C. So generally speaking, one looking at a map like this, what could infer that the areas that are in blue would be well drained and would support septic systems.
How is this map made? Do you know?
Yeah,
Any idea?
it's a national data set that's
Okay.
produced by NRCS.
Okay.
But it comes from a national organization,
Yes.
from a
Right.
United States cabinet
Yes.
department.
Yes.
Okay. And so, the type B soil, and you might have said this, it's well drained and would theoretically support percolation?
Yes.
Okay. And type B is on both the north and south sides of the property.
Yes, it is.
Any other questions regarding the maps for the board members?
Permeability is good.
Okay. I'm finished with the maps for now.
Would you like me to leave these up here for your reference?
Even where they can see them.
Yeah, that's what I
Sure.
was thinking of.
We can put it
This
here.
one here.
This room's not well equipped. There should be a couple.
This could be our
Just put
library.
it all here? Yeah.
Okay. So, Mr. Hine, you received a variance. This is why we're here, a variance request
Yes.
for this property. And in evaluating variances, do you look to the county code?
Yes, I do.
And in evaluating the variance for a forest conservation appeal, do you look at 150.33 variances, which has already been discussed?
Yes, I do.
In evaluating forest conservation variances, do you look at water resource variance appeals under the Water Resource Code?
No.
You look at any other codes when
No.
you're evaluating a forest conservation? No state statutes, federal statutes, when you're evaluating a forest conservation easement variance request, you follow the 150.33, which is the Forest Conservation Code in Carroll County.
Yes, I do.
Okay. And, excuse me 1 second as I pull out Exhibit 5. Right there. And you received a forest conservation variance request for this, which you ultimately denied, is that correct?
That's correct.
I would like to introduce into evidence your denial letter. Clark, I have a copy. I don't know if you want another copy. It's from August 15th.
Well, if you got an extra one, I'll take it, but, so it has, because he has the exhibits marked on, that's helpful to me.
Yeah.
No objection.
Mr. Hine, can you please read to the board the letter, I guess, starting with, per the request of Mr. Schaefer? Can you just read from that point on?
Sure. Per the request of Mr. Clark Schaefer, attorney for the developer, I have proceeded with review and decision regarding the variance request for the Kuhn property. It is my determination that there is reasonable potential for the off-conveyance to be located on the north side of the property and thereby not require the extinguishment of the existing forest conservation easement. I have therefore disapproved the request for variance. My findings report is attached to this letter. Do you want me to continue with the next paragraph, or?
Just hold on one second. And then, you provide, also in that letter, your findings, is that correct?
Yes, it is.
Can you please read to the board your findings, with regard to the, variance request?
Are we going to really read 3 or 4 pages of findings that's already
We
in the
spent
record?
an hour and 45 minutes on your testimony. I would like to spend at least 20 minutes on mine.
I object. It's in the record. It speaks for itself. I don't mind him testifying about it, and I don't mind him cherry-picking some stuff out of it, but I think it's, well, I object.
If overruled, we will allow it and give it the weight it deserves.
Okay, this application for variance VFC 22009, submitted by John Lemmerman of RTF, requests relief from the Carroll County procedure for release of forest conservation easement documented in L3 of the Carroll County, Maryland Forest Conservation Technical Manual, the manual. The policy for which relief is requested is that Priority 1 forest is not eligible for release of easement. The specific request.
Can you hold
Yes.
up for right there? So that priority 1 forest in opposition exhibit 1, that represents the sort of triangular marking on the map. Is that correct?
Yes, it is.
I'm going to object here, and I'm going to explain my objection. I have not objected to repeated, leading questions from Mr. Allman of Mr. Hine, because in most instances, I felt that they just moved the case along and it were not objectionable. But what is occurring, and on this one it's substantive, is Mr. Allman posits an answer. Do you believe that the reason the Priority 1 forest was that, and Mr. Hine then goes, yup. And then Mr. Allman testifies again and says, and wouldn't you say that that's the reason why, that's what he just did on that question, is he said it, and then Mr. Hine says, yup. And then he goes, well, wouldn't it be true? Yup. We need Mr. Hine's testimony based on non-leading questions, especially when his own attorney is asking the question. This is not cross-examination where you could presume Mr. Hine is an adverse witness and doesn't really want to say stuff. He's testifying for him, so I object to it.
I was asking Mr. Hine to read the his letter, and for the edification and just for the help of the board members to point out what he's referring to. But I will bring that up in my closing. So you can continue with reading the letter.
The specific request is to release a portion of Priority 1 forest easement to allow for the construction of a driveway to support the development of an off-conveyance residential building lot. The subject property is located at 3033 Salem Bottom Road, Westminster. The property is bisected by Morgan Run with an existing residence to the north of the stream and undisturbed forest to the south of the stream. The applicant desires to subdivide an off-conveyance on the portion of the property to the south of Morgan Run. To facilitate access to the property south of Morgan Run, the applicant obtained 1.132 acres of property adjacent to Salem Bottom Road that was owned by Morgan Run Stables LLC in 2019. The 1.132 acres includes a 0.58 acre forest conservation easement that was created in 2009 as part of the residential subdivision, The View at Morgan Run. Given the steep slopes and proximity to Morgan Run, the forested area within the subject easement is rated as Priority 1 as defined by the manual. The location of the forest conservation easement is such that access from Salem Bottom Road to the remainder of the southern portion of the property cannot be achieved without release of a portion of the easement. The applicant has requested a release of 0.084 acres of the easement to allow for the construction of a driveway to a proposed residential dwelling. The applicant is requesting a variance request pursuant to Section 15033A1 of the Carroll County Code, which states that, A, the county may grant a variance from any of the technical requirements included in this subchapter if there are exceptional circumstances that, 1, strict adherence to the provisions of this subchapter could result in unnecessary hardship or environmental degradation. The applicant asserts that compliance with the policy in the manual that extinguishment of priority on forest is not permitted is an unnecessary hardship. Pursuant to Section 15033C, the applicant must submit a written request for a variance which meets the following requirements. Number 1, describe the special conditions or exceptional circumstances peculiar to the property which would cause the undue hardship or that prevent the applicant from complying with the subchapter with on-site or off-site mitigation and any evidence that compliance would result in an environmentally degraded condition on or off-site. The applicant claims undue hardship in that the right to develop an off-conveyance on the subject property is not possible due to the restriction of the forest conservation easement. The applicant asserts that due to several factors, development of the off-conveyance on the north side of the property is not feasible and therefore must occur on the south side of the property. The applicant states development on the north side of Morgan Run was deemed not possible due to steep slopes. However, LiDAR data and derived contour mapping indicates that there are many portions of the property north of Morgan Run that are substantially flatter than the proposed area south of Morgan Run. The variance application states, the owner-developer is a contractor by trade who performs perk tests and installs in septic systems, and it was determined that any usable ground on the north side of Morgan Run would not support a sewage disposal area, just a potential septic system replacement area for the existing house. However, no evidence was provided regarding actual percolation test data on the north side of the property. Furthermore, hydrologic soil mapping from the Natural Resource Conservation Service represents that the predominant hydrologic soil type on the north portion of the property is B, which is characterized as well-drained soils and would theoretically support percolation. Additionally, no discussion was made regarding the feasibility of alternative solutions such as sand mound septic systems. Available evidence indicates that the development of an off-conveyance may be feasible on the north side of the property, thereby allowing the Priority 1 forest conservation easement on the south side of the property to remain intact without causing an undue hardship to the applicant. Shall I continue? Number 2.
Yes.
Demonstrate in sufficient detail that the granting of the variance will not confer on the applicant a special privilege that would be denied to other applicants. This request is not viewed as a special privilege that would be denied to other applicants. Number 3, demonstrate in sufficient detail that the variance request is not based on conditions or circumstances which are the result of actions by the applicant. The applicant has chosen to pursue the development of an off-conveyance lot on a portion of their property that requires the extinguishment of a Priority 1 forest conservation easement that is specifically prohibited by county policy. The applicant states that the off-conveyance must be developed on the south side of the property because the north side was deemed not possible due to steep slopes, existing improvements, and associated well and septic areas. As discussed in item 1 above, evidence has not been provided regarding limitations of steep slopes or well and septic areas. Regarding existing improvements, this includes an unpermitted contractor equipment storage yard, which should not be an impediment to the permitted residential development right. Therefore, the conditions and circumstances of requiring the variance are the result of action by the developer both in creating the unpermitted use and in the choice of location of the proposed off-conveyance. Number 4, demonstrate in sufficient detail that the variance does not arise from a condition relating to land or building use permitted or non-conforming on a neighboring property. This request is not viewed as a situation arising from a condition on a neighboring property. Number 5, demonstrate in sufficient detail that the granting of a variance will not adversely affect water quality or result in an environmental degradation condition on or off-site. The applicant has stated that the proposed preservation and mitigation are sufficient to offset the proposed environmental impact of releasing the forest conservation easement. It is found that the applicant has not met the requirements of Section 15033C1 and 3 of the requirements for approval of a variance. Therefore, this request is not consistent with the spirit and purpose of Chapter 150, and the variance is disapproved.
You can take a drink before I ask you.
I'm good, thank you.
Just a few questions and then I'll be done. Is it fair to say, Mr. Hine, that this is the reasoning in which the variance request was denied?
Yes.
And that variance request is what was introduced as Opposition's Exhibit 2, Applicant's Exhibit 5. Pursuant to County Code 150.33, requesting a variance from the technical requirements release of forest conservation easement?
Yes,
So it was a variance for the forest conservation easement.
yes.
And that variance was denied, apologize, was denied because the information and the evidence provided by the applicant did not, in your opinion, amount to the unnecessary hardship requirement to grant a variance.
Objection leading. He's going to say yes, we all know that, but he's not testifying.
I think we should let him give the answer.
Yes.
And just. When you were considering the forest conservation variance, did you look at the water resource management code?
No.
I have no further questions at this time.
I do have some cross. Is now the time?
Yes.
Okay. So, I heard you say you didn't look at the Water Resource Code when you were considering the variance, but were you aware that this off-conveyance application was in process and being reviewed through your department at the time you looked at this variance?
Yes.
Because you had previously granted a water resource conservation easement, correct?
Yes.
And so you were familiar with the property, at least from that perspective, correct?
Yes.
And when you granted that water resource, you didn't know about the contracts equipment storage yard?
No, I did
Again,
not.
this has been asked and answered.
Well, I didn't remember the answer, but apparently he's saying no. And then, how familiar, so are you, you've testified as to your familiarity with the property and shown the maps and pointed out soil types and stuff, correct?
Yes.
You ever visited the property?
No.
You ever conducted any physical tests or inspections on the property?
No.
Okay. You have taken great pains through your attorney to introduce evidence that suggests that the northern portion of the property is buildable. Is that correct?
I don't know if I would categorize it at great pains, but we have provided the information that was available to me as part of this review.
So you did a paper investigation of the environmental characteristics of this property and then came to the conclusion that the northern portion was buildable, correct?
Yes, I need to make a determination based on the evidence provided to me and common information that's available for my analysis.
Okay. But you don't know if it's really buildable, do you?
I do not.
Okay. Many a slip twixt cup and lip when it comes to trying to get a building lot permitted, correct?
You'll have to define what you mean by that.
Lots of things happen that can prevent you from getting a final governmental approval after a year or so of review. Is that correct?
There is a process that development requires that we go through based on county code, yes.
I mean, the health department requires perk test. You think they'll be successful based on your investigation, correct?
I was not provided information that substantiated that perk tests would not work on the north side.
Let me ask the same question. Based on your investigation, did you testify that you thought that perk tests would be successful on the northern portion? I'm not asking if they would be, but did you think they would be?
There's a better chance that they would than not.
Okay. And the well, you didn't do any kind of hydrological study, did you? So you don't know if a well's good up there, right?
Nope.
Did you look at the site distance where the driveway would enter that, if it were located, where it would enter the northern portion of the site?
No.
Okay. Do you know, well, never mind. I've made my point there. All right, so am I to understand then, based on that testimony, that the essence, aside from the contractor's equipment storage yard, that the essence of your rationale for denying the variance was you could locate this on another portion of your property, this off-conveyance?
The variance application did not substantiate to me that that was not an option.
Is it your testimony that in order to get a variance application must substantiate that to you?
Yes.
Remember my hypothetical about the 100-acre farm and the guy wants to take 1 acre off in the front?
I recall you mentioning that, but
And he needs a water resource or he needs an easement, a forest conservation easement from a priority one forest in order to do it? Because that's where he wants his son to live? It's hypothetically? Remember that?
I remember you talking about that,
Okay.
yes.
And I ask you, would you, if you analyze that, would you then look at the rest of the farm and determine whether or not there was another place that, again, same investigation you did here, look at the maps, get them and say, I'm not going to give you this variance. You could put it over here. Would you do that?
I can't answer to hypotheticals. I look at all of the information presented to me in the variance request.
But you did that here,
Yes.
and that's one of the reasons you turned down the variance.
I turned down the variance because the indications were that the preference was to be on the north side and that there were factors as listed in the variance request that prevented that. Again, it is a constraint, a legal constraint to putting the property on the southern side, and development needs to work within all of the constraints.
I understand, I understand why you're reading your decision, but if I make a variance application and in it I make a statement that is not supported, okay? In other words, which you're saying that's the case here, right? That the application contains a statement which is basically can't use the northern portion or it's restricted use, and you're saying that's not supported, right?
Correct.
Okay. So that's part of a variance application, right? Does that go ahead.
Yes.
Does that then end a story, disqualify the person from getting the variance? If they have other reasons why they might have a hardship?
No, and actually, if you recall, my first response to the variance was that I could not hear it because of the contractor's equipment storage yard, and then at the end of that, I recommended that additional information be supplied. But then your request was to go ahead and move forward with reviewing the variance request with the data provided.
Chris, what you said is further information required. What you said is, I will not consider your variance application until you clean up the contractor's equipment storage yard. And when you do, you may submit another variance application with additional information. That's what really happened, isn't it?
Well, yes.
Okay.
We're talking semantics. It's essentially indicating the same thing,
Okay.
which is that there was not enough information from my perspective, and I was recommending a course of action which would substantiate their claims.
And in real life, I think you testified, and I'll ask you, in real life, the practical effect of that letter would have been that the applicant could not achieve his off-conveyance approval for approximately 1.5 to 2 years.
But that is not an undue hardship. and
Well,
that's
I
not
didn't
a-
ask you whether it was an undue hardship. I just asked you if that was true. In
Yes,
real
that is true.
life, that's the effect of that letter, right?
Yes,
But you don't think that's a hardship?
it's not. It's the
Okay.
process.
Do you think it's a hardship that Mr. Kuhn applied for a off-conveyance in August 30th, 2021, achieved all agency... achieved all agency approvals except this one, and then found out, including a variance from your own department, indicating you were familiar with the property, or at least your department was, and then was told on the date of your letter sorry, bud, can't qualify, no off-conveyance approval for you. Do you think that's a hardship to a property owner?
No, that is the process.
Well, the off-conveyance application filed in August 30th, 2021 contained evidence that there were forest conservation easements on the property, did it not?
I can't speak to that. I did not see it.
Well, there's a title report in there that refers by Liber and folio number to the forest conservation easement. Do you deny that that's the case?
I can't affirm or
And
deny.
then the county, 10 months later, or whatever, I don't know, there, says, sorry, okay, I'm sorry, I already did that. But I think your answer is, it's not a hardship in your opinion.
No,
Okay.
the county has a process for development, as outlined in chapters 155.
Now, your testimony with the maps, and I think everybody remembers basically what it was designed to be a tabletop, to evidence a tabletop look at a piece of real estate to determine its eligibility for development. Is that correct?
No. I would say that we were looking at the evidence available to myself in making the determination of the variance request.
Well, perhaps the word tabletop was not clear, but you never went to the site, you didn't get any studies, you didn't do anything other than look at paper on a computer screen or real paper. Is that correct?
That is correct, because the
And-
burden is on the developer to submit the information for my review.
Well, not here, because the developer didn't have any obligation to present evidence to you on the northern portion of the property, did he?
When the argument is made that the preference would be on the northern part, but it's not possible because of certain factors, then information about the northern part of the property is certainly applicable.
Well, why didn't you ask for it shortly after February 22nd, 2022 then? Why'd you wait 6, 7 months to ask for it?
I did not see this variance request until June 15th.
Well, I mean, it was in your department, right?
I did not see this variance request until June 15th of 2022.
You don't think it's a hardship that that your department waited that long?
Objection.
I ask him if it's a hardship.
No.
Okay. Now, in fact, you're well aware that the tabletop, as I refer to it, review you conducted is just a first step in actually achieving any kind of development, correct?
I'm not sure I quite understand. There's a prescribed process of review and approvals that go through county code for development.
That entail more than looking at the maps you showed, right?
Correct.
That review process entails more than that, correct?
Yes.
Okay, thank you. I mean, because if it were that easy, all these land use consultants would be out of business, wouldn't they?
Is that really a question?
Yeah, it is. I mean, is it really that easy to analyze a piece of property like this?
There is a process that each technical agency goes through in the evaluation of subdivision, and it includes a variety of investigations and et cetera.
One more. The priority forest. That evaluation's based on a set of criteria that you mentioned, steep slopes, water. There's a list of them in there, isn't it, in the code?
I would defer to John Bowman. I'm not an expert in that.
Well, you testified on direct examination about what a
Yes.
priority forest
And in
was.
my testimony, I said that I'm not an expert. My understanding is exactly what you just said, which is that it's based on steep slopes and proximity to water bodies, et cetera. But the exact definition, I would defer to John Bowman on.
And everybody in the industry knows that that's a starting point. Is that correct, to evaluating the environmental effects of a forest conservation easement?
I'm going to object to that. He doesn't know what everybody in the industry thinks. Chris isn't clairvoyant. He's many things. He's not clairvoyant. He doesn't know what everyone in the industry thinks the starting point of development is.
Is Priority 1 forest designation a designation that occurs as a result of a application of a broad set of criteria to a large land area?
I would have to defer to John Bowman on that.
Well, you talked about steep slopes and water resource, right? You look at those, right? What's the one that got this one in priority one, do you know?
I can't say specifically, but I assume that it's both, because it's immediately adjacent to Morgan Run and it's steep slopes.
Okay, whatever. But do you admit or acknowledge that, in fact, you really need to look at the specific forest involved in order to analyze how valuable it is environmentally? In other words, you might have a 60-acre piece that's priority forest. If somebody applies for a variance through the edge of it, do you look to, does the analysis include, let's look at that part of the forest and see what you're doing down there?
So I had no evidence to indicate that there was a question as to whether the forest was priority one or not. Nobody was arguing that it was not.
Excuse me, I'm not arguing that
Okay.
it's not.
Okay. I base my decision on the information that's submitted to me for my review.
Did the information submitted to you for review include the fact that there are any specimen trees in the area?
No.
Okay. Did it include that there's any water resources in the area that would be damaged by the easement?
I would have to go back and refresh my memory, but I do not recall.
Well, you're welcome to go read whatever report you want to read, but I don't think there is, but I'm asking you.
Again, I would have to refer to the staff report.
No, go, feel free.
So one of the statements is, in the description of the creation of the easement, it says, the view at Morgan Run was a subdivision recorded in 2009. It resulted in the recordation of 2 forest conservation easements over existing streamside forest. So that's one indication of environmental, let's see. No, I do not see any additional mention of that.
Okay. Now, your code contains at 150.26 a retention priorities section, right? The Forest Conservation Code?
I would need to refer to the code.
Okay, well, do you have it? I mean, I've got a copy, but I'm not, I've got a copy of one page.
This is, you said 150.26?
0.26.
Oh, wait, this is 155. No, can you hand me the binder? Thank you.
And by the way, I think that's one of the ones that did not change by my reading when I got the new supplement yesterday. So I think that whatever you have there, hopefully is up to date.
Yes.
Because you're the administrator.
152.6, retention priorities.
Yeah, that's the section.
Yes.
Okay, it talks about retention priorities, doesn't it?
Objection. We're here for a forest conservation variance, not talking about the wisdom of retention priorities and the county
He
policy.
testified that one of the reasons he considered this a tough one was it's in a priority forest area.
He also mentioned that in his letter.
Overruled, we will allow it and give it the weight it deserves.
Okay, any of those items in B, the following categories of trees, shrubs, or other forests located in specifically identified sensitive locations shall be considered a priority for retention and protection. Remember that section there? right?
So again, we're getting into the weeds, as it were, of forest conservation law, which I am not.
I'm not in the
expert
weeds of
in.
law, I'm in the weeds of facts. You have a staff
Objection.
report, you have a staff report, you just referred to it, right?
Yes.
Does that staff report talk about any sensitive any items that are identified as sensitive in your own code as being in this forest, this 08-acre area?
No, the extent of my review is based on the facts presented to me, which include a staff report, which indicate that this was a priority 1 forest.
Period, the end.
Period, the end.
Now, I'll just also just point out to you, do you see at the top in section A, the last line in section A? Under retention priorities?
Trying to find the beginning of it, it seems to be a long sentence.
No, well, okay, yeah, go ahead.
The last line, existence would either be economically prohibitive or otherwise unwarranted. Is that what you're referring to?
Yeah, what I want you to say, well, I'll tell you what I want you to say.
Yeah, what do you want him to
I
say?
want you to say is you recognize that economically prohibitive is part of the analysis that the code suggests should be considered when addressing variances and other relief under the code.
You can read what you want to
This section
read.
is not related to variances. This is just about retention priorities. It does not say that, to my knowledge, in the variance section.
Well, I won't read it because it says what it says, and I don't know if you have it up there, but I do. Okay, now, I'd like to get this marked as identification as my 7?
8.
8. Yeah, good. Top's good, thanks, Tim. Showing you a photograph, do you recognize what that shows?
Substantively, yes. I mean, it's trees and a roadway.
Okay. You have no idea whether that's the area that we're talking about here today or not?
Nope,
Okay. You've never seen that area?
no.
I'll introduce this through Shorty Coon when he testifies. Right. We'll leave it up with you until then, because I'll probably lose it.
Okay.
I think I'm almost finished. Let me just double check my notes here.
What is the name of that exhibit?
Photograph Exhibit 8.
Just a photograph, Exhibit 8? That's what it is?
Well,
You kind of jumped the gun.
I introduced it for identification, meaning it's not in evidence. But in order to put it in evidence, I need to authenticate it. And in order to authenticate it, I need to call a witness that'll tell what it says.
Okay.
I'll
So you
proffer to you
okay.
that that's the area, that's the .08 area. That's generally, that's the area where the driveway would go. And Shorty Coon will testify, he took the photo, when he took it, and whose pickup truck that was.
That when the road was paved.
And that's all I have for Mr. Hine.
I just have a few questions on redirect. Mr. Hine, to reiterate, you received a forest conservation variance request under Chapter 150, essentially.
Objection asked and answered.
In that request, you looked at Chapter 150.
Yes.
Can you say what portion of Chapter 150 you looked to in determining whether or not to grant or deny the variance?
Section 150-33, which relates specifically to the variance request.
Okay, and is there any requirement that the head of the department or bureau chief visit the property that they are, analyzing a variance for?
No, there is not.
And it's, and you were, is it fair to say that you are looking at you are applying the variance request from the applicants to section 150-33 of the county code.
He's testifying for him. He'll say yes now.
Well, actually, I would like to elaborate just a little bit on it. And I think I've stated this before. What I am presented with is evidence and facts that I need to base my decision on. Yes, there's the potential to go out and go out and visit and so on, but what I'm required to do is look at the evidence that's provided to me and evaluate it versus 150.33C, which are the requirements to allow me to issue a variance, which is what I did.
So you didn't look at the variance request to determine the development potential of the property?
No.
You didn't look at the variance request to determine the beauty of the
He'll
property?
say no again.
Excuse me, please let the witness answer.
You didn't look at the variance request for, the different types of trees on the property?
No, I can only base my decisions on the law, and the evidence presented to myself.
I have no further questions.
No follow-up questions.
I call you next witness, Mr. Schaefer.
Does the board have any questions?
No, I'm good.
Call John Lemmerman. John, will you state your name and address for the record, please?
Sure. John Lemmerman, registered professional land surveyor and planner of RTF Associates. Lemmerman is Lemmerman.
All right. Mr. Lemmerman, could you briefly describe your background and experience with regard to Carroll County zoning and development?
Sure. I've worked at RTF since 1989, so that's over 33 years. Been licensed professional for 21 years. I've owned the business for 17 years. The majority of my business has been in Carroll County in land surveying, planning, and development.
Mr. Schaefer, just to speed things up, are you trying to get him in as an expert witness?
I am, but I want to ask him a couple more because I think his background is
Okay, I was
important.
just, because I've worked
You were
with
gonna
Mr. Lemon in the
stipulate-
past, I
yeah.
would have no objection to him being,
Well, then I'll
expert.
go ahead and I'm fine with if you're going to accept that. I'd like to offer him as a qualified expert in the area of land planning and design.
yeah, no objection.
And can I get a nod and a wink from the board?
Yeah.
And I just saw a nod and a wink and a yeah. The transcript doesn't recognize the nods and winks.
He's accepted as an expert in
All right,
land
good,
planning
thank
and
you.
design.
So, John, in that capacity, have you processed more than a few plans through the Carroll County subdivision review process?
Yes.
And did there come a time when Carroll County adopted what I'll refer to as the environmental codes?
Yes.
And they've reviewed and amended them over the years, correct?
Correct.
And that's, 15, 20 years ago when they first adopted these codes? Do you know?
I believe the Forest Conservation Code might have been enacted in 95.
Okay, all right. Now, and have you dealt with forest conservation easements and policies and practices during the course of your career?
Yes, very much so.
Now, you're, of course, the consultant that, along with my office and Mr. Kuhn, filed the off-conveyance application. Is that correct?
Correct.
Right. Now, prior to filing an off-conveyance application, do you do any work on behalf of the property owner?
Yes, extensive.
Well, go ahead. And John, you're a little soft-spoken.
I'm sorry.
So I want to make sure everybody can hear you and the transcript can hear you.
Okay.
Go ahead.
So yes, typically, if you're going to pursue an off-conveyance, the first step is doing some deed work, going out to do some land surveying of the property, doing some mapping, topographical mapping. You lay out proposed lots based on the topography and your knowledge of the regulations. You submit plans to the local health department for review and approval to perk test, and ultimately dig the perk test, resubmit with the perk test results and your layout of your lot, so they approve it for perk test and well, in this case, otherwise it would be public water and sewer. And,
Wait a minute, John, you do that before you file the off-conveyance application?
oh, yes, because.
Why?
Because you have to determine if it's a viable, even a viable option to build there before you even get involved in the rest of the process.
So otherwise, you would perhaps file an off-conveyance application and then find out you couldn't even meet the basic requirements for development of the site, correct?
Correct.
So you did that in this case?
Yes, absolutely,
And did you do that in consultation with the property owner?
absolutely,
Did the property owner pay to have that done?
yes.
And did you consult with the property owner as to his preferred location for his son's lot and house?
Yes, yeah, he actually was shooting for hoping for 2 lots because he has 2 sons, but unfortunately we could only get 1 there for the environmental restrictions.
And so this is obviously the one that you applied for?
Correct. So after the health department work, basically, typically the next step is doing a forest stand delineation, field visit, plan and report, and then get your plans together. You have to address, before you can submit, you have to do stormwater management, computations, analysis.
Before you can submit what?
Before you can even submit to with an off-conveyance application.
Really?
Yeah, you have to have a complete package together for every department to review to go in with the off-conveyance application. So yes, you have to address every agency's work and requirements in a package that goes in at one time. So before the submittal, there's a significant amount of work, time, and effort involved.
Well, let's talk about the stormwater management part of that. So you're telling me you needed concept stormwater management approval for this location before you even submitted the application?
No, we just have to address stormwater, get through the computations, do the design, and the reports to submit for review.
Okay, so you do the work and then you submit it with the off-conveyance application?
Yeah, every department that you have to submit to with an off-conveyance application typically has their own checklist
I have to
requirements.
ask a question. Is this for permitting? Is this permitted? For permits?
Well, this is to get an off-conveyance approved, then you get permits at the end of that process.
Okay.
You know, we're not even close to permits yet.
Okay.
And for instance, this is a little out of order, but the stormwater management review that occurred for this off-conveyance at this point, has occurred, correct?
Correct. We actually have every approval required except for forest conservation on this project, and development reviews, but all their comments have been addressed. They just typically don't give you an approval letter until all the other agencies have done. So those approvals include floodplain management, because we're not affecting it, stormwater management, which by their own requirements retains, after you address their requirements, retains 100% wooded hydraulic status of the site even after development.
What does that mean?
That means the numbers that you have to meet to address stormwater management and the options that we were given in the state manual and local manual is hydraulically, the runoff numbers are intended to be fully wooded even after development.
Okay, so you're going,
And that was what Carroll County has told the Carroll County chapter of surveyors when it was being implemented, so.
okay, so you went, I'm going to interrupt you because I want to show this. I'm going to show you this. This is 6.3. Okay. 6, page 3. I'm showing you what's in evidence as Exhibit 6, page 3. What is that? Do you recognize it?
Sure. After you get stormwater management approval, part of that final requirement is to, and this particular design and how it was addressed, besides level spreaders that are going to sheet flow runoff, there's a conservation easement that is 1.552 acres that's below the proposed off conveyance. So it'll be on the remainder parcel being offered to the county.
Okay. And
And that's the exhibit plat that will get attached to the deed of easement that gets recorded.
Page 3, but for convenience of reference, I'll show you that this is the off-conveyance lot, which by now you're familiar with the outlines of. This is the stormwater management conservation easement off the lot, on the parent tract, is what he's talking about. Again, this will be required to be deeded before the off-conveyance will be finally approved. Right now, we know that it is required and that it's part of the approval process. Now, does that provide environmental benefits?
Absolutely.
What kind?
Environmental benefits,
Yeah, I
you
mean,
said?
what can't you do in the stormwater management easement?
It's a permanent conservation easement. It cannot be disturbed. It must stay vegetated.
So the property owner, without that easement, the property owner could do a lot in that area of his property or her property, correct?
Correct, including motorized vehicles and things like that.
But with this easement, all that's off the table, right?
To my knowledge, yes.
Does that create an environmental enhancement, in your opinion?
Yes.
So,
Object to that, Mr. Leonardman is an expert in design and land planning, not in, knowing about the different environmental benefits to.
you may want to restate that so it's on the record.
Right.
Begin.
I object to the last answer, that he believed that, basically that stormwater management provides environmental benefits?
Yeah, yeah,
That,
yeah.
as an expert in planning and land design, that he can't speak, as an expert to the environmental benefits of stormwater management, and I'm just putting that on for the record.
Okay, well, my license says.
No. Go, I'll
Excuse
ask you,
me.
what do you have any expertise in that area?
It is part of my profession and my licensing, yes.
All right.
Yes.
Well,
So
okay.
I was.
Go ahead.
Listing the other things that, engineering is approved, which is significant to this situation because this particular proposed driveway access is the safest place and the only place that was approved on the south side of the property.
Wait a minute, did you just say this, the .08 easement variance request is, we all know it's for a driveway, correct?
Correct.
And you're saying that location, and I'm testifying for him, I get it, but he just said it, is the only place that met or came close to meeting site distance requirements?
Yes, so it was the safest location access and the only one approved.
Okay. What are site distance requirements? What are they?
Sure, site distances requirements are measurements from if you are sitting at a proposed entrance, entering onto a public roadway, the distances that you can see in either direction, and those distances are regulated specifically based on the speed limit of the road. The higher the speed limit, obviously further away you need to be able to see oncoming traffic. So it's a public safety issue.
All right, go ahead. Are you finished with your
So with
approvals
these-
or you got more?
No, I'm continuing on with that. So soil conservation has approved it. We have approved sediment and erosion control plans for the construction of the driveway through the woods and everything else, and construction of the house. So Carroll County Soil Conservation has approved that. The sediment and erosion control plans. The health department, of course, has approved it by this point for private septic and well. And then water resource protection, you've heard enough about, but we've got that approval also. And, in those approvals, there's been 5 plans generated as part of this off-conveyance package to address those.
Now, pursuing those approvals, does that involve time, money, and effort?
Yes. In this case, it's been probably at minimal 3 years' worth of time, effort, and tens of thousands of dollars between the surveying, the plans, the processing, and then to get to this point. And quite frankly, I'm personally and professionally offended that it's not considered a hardship, and it's somebody's time and efforts are totally disregarded for the removal of 0.08 acres. of
Okay,
an existing
I
easement.
appreciate that. Were there application fees that needed to be paid to the county in order to pay for these reviews that were conducted?
Yes,
And are they fairly substantial? They're not nominal?
correct.
I mean, you were talking in the, I don't know, it's $8,000 to $10,000 worth, or?
Well, the county review fees aren't quite that much, but as far as addressing forest conservation, excluding the variance request, the reforestation requirements for this one building site is 1.527 acres, and purchasing of a bank is the only way to mitigate it because of the site conditions. So at 16,000 an acre, yeah, he's gonna write a check for over $24,000, 24,432 if it was 16,000, which seems to
No,
be.
wait a minute, he didn't write that check yet. You're saying that based on the approvals you've obtained so far, if he were to go forward with this, he'd be required to buy more forest bank than the .08 acres we talked about, right?
That's correct.
And that would cost money. What are for-
I'd
what
like
are
to
for-
object to this whole line under relevance, just for the
Okay,
record.
okay, we think it's part of the hardship, but he disagrees. But you get to make the call. Now, if, and also, is there going to be a requirement that the owner convey a strip of land along Salem Bottom Road to Carroll County as part of the final approval of this?
That is correct.
And that's for a road widening, that's in case the county ever wants to widen Salem Bottom Road at that point of area, correct?
Correct.
Okay. Now, you've been here all morning, and you've heard Mr. Hine testify, did you not?
Yes, I have.
And prior to that, you were aware that Mr. Hine, at least in part, is basing his evaluation on the ability to relocate this to another piece of property, or another area of the property, correct?
Correct.
Now, and you're familiar with the special purpose nomenclature, are you not?
I'm sorry, repeat the question.
Special purpose plat, you ever heard of them
Oh,
before?
I'm sorry, yes.
They're rare, aren't they?
They are rare.
Are they mentioned anywhere in the county's zoning ordinances or regulations?
Not to my knowledge.
It's a made-up process that the Development Review and Planning have developed to handle certain special situations, correct?
Correct. And in this particular case, if we went that route to relocate the lot to the northern side, it would basically be going through the subdivision requirements and be platted.
All right, that's what I was going to get to. Describe the process as you understand it if the owner was to go and pursue a special purpose plat of the whole property, by the way, is what I'm told. It'd be the plat of the whole property, be platted. What would be the process?
Well, all the work to date would be disregarded, and time and costs and efforts, and we would be starting over with the surveying and the mapping and the health department perk tests, the redesign, addressing forest and delineations on that side of the property, addressing every one of those agencies that I've listed already, and their county fees are more. There's different requirements as far as typically, and I'm repeating this based on experience because I have had experience with other situations where a lot was relocated under those circumstances and it had to go through the subdivision process. So there are a lot of different requirements like road frontage, in-fee strips, the entire property in this case would have to be dedicated parcel A road widening along the entire road frontage, not just the off conveyance. Because that's
So are you saying that the property owner would be required to donate a larger piece of ground to the county, likely?
That's correct.
And in your experience, the lot owner, the applicant would be required to go through pay new review fees for a new piece of ground?
Absolutely, and attorney fees also.
The new title certificate, et cetera, right?
Correct, yes.
Right. How long does the process take in your estimation? I mean, and let's assume that you start today, you would do your preliminary stuff, you just perk and stormwater calculations and everything else, correct?
Correct.
Right. About how long from start to end, if it met all the criteria, if it was able to get through the criteria and get approved as a final special purpose plat with a lot on the northern portion, about how long would that take from today to getting that final approval?
My best estimation, under current circumstances and the situation, a minimal 2 years.
All right. Now, and this parcel of ground is eligible for an off-conveyance, correct?
This particular piece to what we're
Yeah,
proposing it
well-
on, yes, it is.
And is a special purpose plat equal to an off-conveyance in terms of the process you have to go through?
No, you're forfeiting your off-conveyance rights, and you're going through the subdivision process, which eliminates your off-conveyance rights.
Now, you were here and are familiar with the water resource protection easement, correct?
Correct.
All right, and we showed the easement area that was required or will be required around the buildable area. Can you explain how that came to be?
Sure. I was concerned, once I delineated the variable water resource protection buffer, because it encompassed most of the lot, I reached out to county staff.
Let me interject.
Sure.
You were required under county code, as part of the review process, to identify what you refer to as a variable water resource conservation, protection area?
Correct.
Okay, so there's language that tells you how to do that, 100 feet, 60 feet, and you drew that out, right?
Correct.
And then what did you do?
I reached out to county staff by email with a sketch showing how it would encompass the lot, and offered a solution of, offered what I thought was a solution to it showed a easement, basically where the stormwater management easement is now, but below the site, where the steep slopes down to the stream would be. I felt that would be environmentally beneficial trade-off if they, because we
Wait a
were
minute,
always.
is that the stormwater management easement?
I'm saying it's in that location, but
Okay.
I'm not saying that it's it. I was proposing that. Staff came back with Mr. Chris Hines' input, and this was significant time before his review, so he may not have remembered this at the time. But it came back and said, well, the rest of the undisturbed portion of the off-conveyance lot is going to be retained in forest conservation easement anyway. So we'll just make the remaining portion water resource protection easement also. And based on that determination, we filed our variance and ultimately got our water resource protection approval. And variance. Of course.
And so the entire undisturbed area of the site is going, if it's approved, is going to be in this forest conservation and water resource easement, correct?
Say that one more time.
The entire undisturbed area of the site
Oh.
is going to be in this easement, right?
Yes, correct.
All right, and the easement is 2.362 acres out of 3.826 acre total land, right? I mean, I'm reading off the Exhibit A. Okay. So what did you say about leading down to the stream? You thought there should be an easement there, or proposed that you would offer an easement there, or the property owner would offer an easement there?
No, before we did the off-conveyance submittal, while I was addressing the water resource requirements, I delineated it and emailed them a proposal of, hey, here's how it affects the lot. It encompasses the building area and the only usable area on the site. So I proposed, and this is before the submittal, is, significant time before the off-conveyance submittal. Proposed a water resource easement from the bottom of the site down to the stream on the steep slopes, thinking that would be beneficial. And the county came up with a separate solution, which is also beneficial by taking the rest, just, and not affecting the remainder, but adding the easement on the undisturbed area of the lot. And of course, I thought that was a reasonable,
Okay, did you say that occurred before the off-conveyance application was submitted?
yes,
Okay. Part of the process you described earlier, the work you have to do in order to submit it, right?
correct, in preparation.
So there was more than casual discussions between you and Chris Hines' department regarding the environmental effects and sensitivity of this building site, correct?
Correct,
Okay. And the result was that you got a variance and an approval for what's shown on that drawing, correct?
the water resource protection easement, yes,
And then the stormwater was a separate process. You went through that with stormwater department, right?
that's correct.
And that's another department that's under Chris Hine, correct?
Yes, it is.
All right. All right. I'll just, the last, we had a big, I'm not going to spend a lot of time on this, but this tract consists of two what are called add-on parcels, correct?
Yes,
Right. And if you look at 6-4, exhibit 6, page 4. You can see this. Okay. So what are add-on parcels, John?
they are land added to the original parcel.
And there's special little items, unlike the special purpose plat, they are addressed in the Carroll County subdivision regulations, aren't they?
Yes,
And if you do an add-on, if you buy an add-on parcel, you're required to put the magic language in the deed of conveyance, aren't you?
yes.
What's the magic language? I mean, I don't know if you can go from memory. I think I can, but,
I can read it from the deed.
okay. And, well, yeah, let me ask you that. Is that magic language in both of these add-on deeds?
Yes.
Okay, read it out, will you?
After a paragraph in the deed under the legal description, it says, "The land conveyed herein is being transferred to an adjoining landowner to enlarge the grantee's existing property and shall be considered merged under the subdivision regulations of Carroll County with the existing property and of the grantee. Such land conveyed is not intended for development other than the then applicable government regulations." And that's the language in the deed I'm reading here. Which is the north side that Chris Hine has referred to as having flatter slopes. That's on an add-on area. So that's a kind of an important point, because when I'm writing my variances for an off-conveyance request, which is limited to the bounds of the original tract, and it is a factual statement in my professional opinion in this variance request that it cannot be relocated on the north side of the stream on the parent tract because the steep slopes, there's very little room for a septic system replacement for the existing house, which is required for health and public safety reasons by the health department.
Wait a minute, now you're talking about the developability of the northern portion, right?
I am.
Well, go. What did you, I'm sorry, what about the existing house? How did that have an effect on it?
I'm saying the area that Chris Hine has referred to as possibility of relocating the off-conveyance is on an add-on area that had restrictive language that couldn't be developed. So when I wrote my variance request, it was specifically for an off-conveyance request and its eligibility, the fact is that it cannot be relocated to the north side of the stream.
Okay. And in fact, that is the policy and process of the Carroll County, that you can't put an off-conveyance lot on an add-on parcel, correct?
It has been established over and over, yes.
Now, Mr. Hine went back and talked, and they said, well, you can do it by special purpose plat. But anyway, that's where it is. All right. We covered most of this, John, so we'll go through it pretty. Assuming we try to relocate it to the northern portion, The process is start all over, number one, or you described the process. Do you know what sort of easements you might have to give or devote, or whether you'd have to ask for any variances from any of the environmental codes if you try to develop that parcel?
I can't say with any certainty, but I can be certain that there will be water resource protection easements involved, at least evaluated. Same departments, same easements, same environmental concerns.
All right. Done. John, in your opinion, and I'm going to look at the variance criteria I'm looking at Section A for now. Would strict adherence to the provisions of this subchapter result in unnecessary hardship or environmental degradation?
Repeat the question, please, Clark.
Read that. Do you think in this case, if there was no variance given?
If there was no variance given?
Yeah.
Yes, absolutely. I believe it's a hardship.
Yeah. And why?
Well, because again, there's been 3 years' worth of time, effort, money, tremendous efforts and time, and it's being totally disregarded, and the line's been drawn in the sand apparently, over 0.08 acres that is going to be mitigated and offered to be mitigated. So I don't understand with all this environmental stuff what the negativity is environmentally.
Okay. Do you, again, section number 3 of the 150.333, do you believe the water resource conservation easement and the stormwater management easement that are required and will be required are measurable environmental enhancement?
Yes.
Okay.
Can I ask a question? As far as those easements go, the stormwater and the water resources,
Yes, sir.
are you doing anything to that area to enhance it, or is that just you're setting it aside?
No, those are conservation easements, so you're basically taking that and then it's legally
So
protected.
it's not like you're doing anything more to make them
That's correct.
better
But it's
environmentally.
correct. But it's permanently protecting it forever, basically.
And those easements prevent the property owner from taking actions in those areas, correct?
That is correct, yes.
Like you can't even throw your dog waste in that area under the terms of the easements, correct?
I can't verify that one.
Is it your opinion that adherence to the technical requirement is not necessary to fulfill the purpose of the forest conservation ordinance?
I'm sorry, my mind was a little bit behind you. Repeat that one more time, I'm sorry.
Well, if would adherence to the technical requirement, which is you can't have a variance, okay, would that be necessary to fulfill the purpose of this chapter? Would that enhance the environmental benefits?
With the variance
Weighing.
request?
Well,
I'm confused.
I'll read you the language. I don't want to take it out. It says you need to show one of these things, either the first one you talked about, the third one you talked about, or the fourth one, which is it can be proven that adherence to the technical requirement, that is, not disturbing the .008 acres, okay, and buying the forest bank, would not be necessary to fulfill the purpose of this chapter. Do you think it's necessary to have this variance? Or have this, do you think it's necessary to deny this variance?
I do not, because it's being mitigated elsewhere in the county.
Now, at any time in your dealings with the county, including your written dealings, did you seek to deceive or mislead the county with regard to the condition of this property?
No.
Did you seek to hide any aspects about this property that you felt were unfavorable or anything like that?
Absolutely not.
That's all I have for Mr. Lemmerman. I miss anything? Let me ask him, John, did I miss anything you'd like to say on your list?
What do you mean his list?
He's made a note of,
My file notes.
Okay. Okay, I just wanted, I wasn't sure what Clark was referring to.
No, I have file notes in front of me, that's what it is.
I just have a few follow-up questions.
I don't have anything further to say.
that's all I have for him.
All right, Mr. Lemmerman, can you just, and I'm sorry, I just didn't write this down. Can you repeat again who you work for, RTF, what they do?
Sure. RTF Associates, Land Surveyors and Planners.
And what does RTF, what is your day-to-day, what is the mission of RTF?
We do land surveying, we do help with building permits, which addresses agency requirements such as stormwater management, zoning, and everything else involved. We do minor subdivisions, some major subdivisions. We do some simplified site plans and minor commercial site plans.
Is it fair to say that you work alongside developers in what you do every day?
Yes.
Okay. So when you testified that it was your opinion that strict adherence to the provisions of this subchapter could result in unnecessary hardship, you're coming to that from the perspective of someone who works in the development community, not someone who works in a government capacity.
I'm taking that from a view of someone who works in the community, with the community, and watch small businesses go under because of the requirements. So that's my perspective.
You mentioned, and your counsel went through the painstaking process of development in Carroll County and the cost of the development and the cost that has already been borne by the property owners. Is it fair to say that it would be cheaper for the applicants, the property owners, to just develop on the northern side of their property?
Not at this point, no.
When you say not at this point, can you elaborate?
Sure. The north side was not viable option under the requirements for off conveyances, so we moved forward with the south side, and the hardship is the time and effort and costs that have been involved up to this point, and I think it's wrong to be disregarded. For something that's going to be mitigated. I don't think the application was asking for anything that would lower the standards of the environment requirements.
One last question, Mr. Lemmerman, and are you aware that you could have applied for and gone through the forest conservation variance process prior to filing the off conveyance?
I'm aware that's an option, sure.
But that wasn't an option that you undertook in this particular case?
That is correct, because unfortunately, the add-on to the property owner that was sold for the access, the seller, knowing that it was for access to his property and that it was probably knowingly in forest conservation, did not disclose that information to him. And unfortunately, the attorney, and it wasn't, for the record, it was not Clark Schaefer, was semi-retired, and I don't know, unfortunately, it just it's a unfortunate set of circumstances that led us to this point.
Okay.
Can I? When you were describing your process, though,
Yes, sir.
didn't you, one of the first things you said was a search on deeds?
Yes.
Would that have turned that up?
As far as surveying related at that point in the project, we take the deeds and the legal descriptions and plot them. We don't do full title searches, so we don't pick up stuff that, I mean, unless we happen to stumble across it. In this case, we did not, until Mr. Bowman unfortunately let us know in his first review letter, which I thanked him for, and we tried to address accordingly.
So I have a question.
Yes.
When were you contracted to do your services?
My job number is 18-50, which means in 2018.
So you were paid in 2018, that's when you started doing your analysis and your surveying and all this work, and this was done in advance of requesting the variance approval, correct?
Yes.
Okay, so in June, wasn't it June that the official request came in for the variance?
My variance request initially went in February of 22nd of 2022. It was revised and resubmitted. Yes, thank you. May 18th, or give or take a day, 22.
22, okay.
And then, yeah, so.
But
yes.
by then, you had done, you were engaged in trying to do this analysis of getting all the data and approval for the process of the southern part, right? You were working on that, surveying as, before even you made the official request.
Yes, because there's a lot of work to even
Yeah.
get to that point.
But
That's
you're
correct.
spending money and time, but not knowing the outcome of the request for the variance.
Right, so, and part of that is, we did file in February initially, and we got, with 2 variance requests, environmental ones, got one back. I didn't have any reason to believe that there was major issues because that was approved and are perceptive, the same reasons that this variance request was being asked for. It cannot be relocated, in other words, and the hardships.
I just have one final follow-up question. Does the existing driveway that goes up to the northern portion of the property meet site distance approval?
I cannot answer that. We haven't done a official state measurements on that one.
Okay. I have no further questions.
Just a couple follow-ups. Okay, hold up a sec. Let me finish with it, and then I'll talk to you. So, John, you know, you answered the questions about developers. Developers are also known as property owners, aren't they?
Yes,
And is Shorty Kuhn a property owner?
yes.
And do you represent a lot of owners that want to take small projects off?
Yeah, that's our forte.
Yeah. And then I believe you said that somebody at the county, I think it was John Bowman, is the one that first made you aware of the fact that that the driveway was proposed to go through a forest conservation easement, correct?
Yes, unfortunately.
And you said subsequent to that, you then filed your variance request.
Correct.
And then you've been going through that up until Chris Hine turned it down in August of this year or something, right? Correct?
Correct.
At any time during that process, did you have interactions with county staff during that time period?
County staff, yes.
Yeah. At any time during that process, did anybody tell you, hey, this variance, this priority forest easement, this is not happening, or it's unlikely to happen, or you've really got an uphill battle there? Did anybody say anything that to you?
No, but I did get contacted by Jonathan Bowman. It was a courtesy email, I believe, and he requested additional information for the variance request, which we felt we adequately addressed and resubmitted.
Okay. Oh, that was the resubmittal.
Yes.
I got it. Okay. Now, could I have a minute to see what he is trying to get me to address? Which map? One of the big ones?
Yeah, just so they can kind of have a visual.
Can we see the big maps? Thank you.
I would like them to see.
No, we'll get it to them through the evidence process. What are you talking about? We've already said that, we've made it clear.
They didn't see the range. Look at this now. He's looking at this and maybe this. And really, in all of that, all we have is a house. Yeah, I think that's a very important thing for them to see. What you, this is the line that I found. There are no place here. We're no place. Where's the old place? Of course, you're saying we didn't have no, our argument for Stevens didn't have no. But this.
Gotcha. I see what you're saying. I see what you're saying. All right, John, can you, is this marked? I don't know which one it is.
Let me see, Clark. I can, that's exhibit 1,
That's exhibit 1.
or
John,
2.
Two's the.
2, I'm sorry, yeah, that's 2.
We ought to put an exhibit 2 on here, don't you think, Tim?
Yeah, we should. I assumed there was one on there.
It's in the back. Let's check the other one.
10,000 emails to answer.
Jim, what's this one? This is 1, right?
Yes. Yeah, 1, 2, 3.
Okay. Here's 1, 2.
This is one.
That's 1. This is 2, correct?
No, this is gonna be 3.
That's 3,
Yeah,
right,
that's
that's 3. So I need 2, and I'll wait until you're finished. For him? Just a couple. Yeah, bring her down here. Is Tim Berger available? So John, may we approach so we can talk about these up here?
Yes.
You can go.
And this one back here, whoops. Thank you. John, with reference to Exhibit 2, which is this, the original track line would run down about here. This is an add-on, and there's an add-on here. Is that about right? That's correct. Right. The off-conveyance location proposed is over here, right? Correct. Now, when you look at this original tract, or when you look at this tract, you knew this was add-on, right? And you knew this was add-on, right?
That's not.
No, that's not, just from here.
Oh, it's up here,
Right.
I'm sorry. Okay. And so you knew, or at least you testified, I can't do an off-conveyance there, right?
Correct.
Okay. So then you look at this site and you go, where can we put an off-conveyance lot, right?
Correct. So this is my options for off conveyances. This is the only area that is adequate topography-wise to get a lot.
So that's,
I have a quick question.
This is kind of a cliff.
Yeah. So those other outbuildings up there, those are on the add-on number 1?
that is correct.
Okay.
Okay, thank you.
Are you finished? Because I have a follow-up with John. Just one question.
I'm on, let me just, give me a second.
Yeah, no, for sure.
Forgive me, I'm still walking. Yes, I am finished, thank you.
Okay. Just one quick follow. You testified that you're familiar with the county's process of special purpose plats.
Yes. Yes.
Could a special purpose plat be used for an off conveyance on the northern portion of the property?
No, at that point, you're forfeiting your off-conveyance rights and you're going through subdivision process.
But you could develop it.
You can attempt to, sure.
Right, okay, you could attempt to develop it, correct?
Yes,
Okay, thank you.
sure.
No follow-up questions? So,
Oh, I have
are you
no,
finished?
yes.
Okay. Okay, I've got Shorty Coon as a witness. He'll probably be 15 to 25 minutes. Do you want to go straight through?
Yeah, let's just,
May we have a 5-minute bathroom recess?
Yes.
sure.
Thank you.
Thank you.
Can I just say one thing to him? It's private.
I would like to call David B. Kraft to the stand. David, now, at the beginning of this hearing, you stood up and raised your right hand, swore to tell the truth, the whole truth.
That's correct.
Okay. Can you just state your name for the record?
David B. Kraft Jr. I am Development Review Coordinator 2 here at the Carroll County Office Building, 225 North Center Street, Westminster, Maryland.
You got that down pat. How long have you been in your position?
So I've started at the county at this position on November 15th, 2018, so a little over 4 years.
Gotcha. And can you explain your responsibilities as part of your job?
So whenever a property owner, a developer is looking to propose development within Carroll County that would encumber on Chapter 155, I am one of 3 or 4 that review that plan for Chapter 155.
Are you so you're familiar with Chapter 155?
Yes.
Okay. Were you present when the previous witness, Mr. John Lemmerman, was testifying?
Yes,
Did you hear his testimony?
I did.
And I apologize, I'll be paraphrasing. He testified basically to the effect that because there is the add-on deed to the northern portion of the property, that the there could be no off-conveyance right, or something to that effect. In your opinion, is that correct?
No.
Okay. Can you please explain to the board why you feel that that is incorrect?
So I feel it is incorrect, and to fully answer this, I'll have to give some background. So as Mr. Schaefer had noted, within those 2 add-on deeds, there is a section in there that mentions no development unless accessory uses. That was put into the code after the county had required any new add-on pieces to have a new meets and bounds description provided. After the county required that back in the day, there was opposition mostly from farmers in the area who said that having to survey their whole property would offset the price that they were even paying for this piece of land. Having roughly 70% of the county being agricultural zoning property, with the majority of that being farmers, the county seceded and said, okay, when you do have an add-on deed, you have to put this piece of this paragraph in that deed, so that way it is clear to the tax office that this is not a new piece of land, but it should be combined with your current piece of property.
I'll just make an objection for the record, because I understand you'll accept this anyway, but this is being based on hearsay that he's heard from other people about the history of development rules in Carroll County. I'll just make that for the record.
I will note, I was not present. I may not have been alive when those conversations were had.
And there are no written records of those legislative proceedings, are there, that you know of?
Not that I know of.
Okay, so you're basing this on what people have told you or talked to you about over the years, correct?
I am basing this on my training for this position.
Your training for the position
Correct.
allowed you to ascertain the legislative intent of the county commissioners back in 1978?
Clark, you'll have this opportunity to cross-examine him
Okay,
when I'm
okay.
finished with my direct. So, with the property, the Coon property, as we've been discussing all day, has an add-on to the northern portion, correct?
I believe that's correct.
Okay. Can they use their off-conveyance rights on that northern portion?
After following a new meets and bounds description, yes. And that would be done via the special purpose plat that was mentioned previously.
And can you just sort of explain what a special purpose plat is?
So a special purpose plat, as Mr. Schaefer had noted, is not necessarily annotated in our code. It is merely a plat of record that is recorded with the state of Maryland that shows the meets and bounds of a property, and it serves a certain purpose.
I have no further questions.
All right, here we go. So, special purpose plat is not mentioned anywhere in the subdivision regs, right?
That's right.
There's no process describing it, there's no right to it in writing in the subdivision regs, right?
It is not written down.
Yeah, and in fact, the subdivision regs talk about off conveyances and subdivision plats, right? There are two ways to divide property in Carroll County. One's by off conveyance and the otherwise by subdivision plat, correct?
That is correct.
And special purpose plat, you've added to that, correct?
That's not correct.
Oh, no, what's wrong with that?
So a special purpose plat is not creating a new lot of record. It is merely showing current property boundary. So it is more or less an recording what currently exists on site. There's no new properties being created through that process. So a special purpose plat would follow what we would call an amended plat process. It would not be a new creation of land.
You just make up the process for a special purpose plat, don't you? I
No.
mean, you apply different processes to different special purpose plats, don't you?
I do not.
How many special purpose plats have you handled in your 4 years?
One or two.
Yeah, they're very rare, aren't they?
They are.
And are they for various purposes?
They are.
Have you ever handled one that was for an off conveyance?
I personally have not.
Okay. Now, you referred to meets and bounds descriptions, right? Meets and bounds, created by meets and bounds, right? Lots created by meets and bounds.
You have to refresh my. I referenced lots created by meets and bounds.
Well, he asked, Mr. Ullman asked you, can they use the off conveyance rights on the northern portion? And you said, well, they would have to follow new meets and bounds.
Oh, correct. Yes. So they would have to have a new meets and bounds description of that parent property with those two add-ons.
What's the, well, how about the lot to be created?
That would be determined through the off conveyance process.
Okay, well, can you read me the definition of off conveyance lot out of your subdivision regs? And by the way, that plat would be recorded, you said, right?
So that plat would be recorded. That's correct.
Can you read me the definition of off conveyance lot?
A buildable lot which was created by a legal division subsequent to April 23rd, 1963, but created without being described on a lawfully recorded subdivision plat.
Okay, so how do you reconcile that definition with your statement that we could move our off conveyance and not lose the right, but we need to put it on a recorded plat?
Well, you would be platting the original property, but you would not have to plat the off conveyance lot.
It's going to be shown on the plat, isn't it?
The off conveyance,
lot?
not to my knowledge.
Well, so you would require the property owner to plat their whole property. Let's say they own 40 acres. And then you would record that plat in the land records, right?
Yes.
And that would show a 40-acre piece of ground.
Yes.
And then you would create your off conveyance after that?
Once the new description has been made, yes.
So it's a two-step process to get there. So that you're telling me that's the equivalent of an off conveyance? Isn't that more onerous for the property owner
What do you
than an off conveyance?
What do you mean?
You know what the word onerous means? More difficult, more expensive, more time-consuming, more burden?
It is additional steps, yes.
Yeah. And so it's not really the equivalent of exercising your off conveyance rights, is it?
It would follow the same off conveyance process. So It's not the exact same as if they were to put this lot on a portion of the parent property.
So how much does it cost to, say I own a 100-acre farm, I'm gonna be hypothetical again, because I own a 100-acre farm, I want to do this. You're gonna special purpose plat me, let's say. You know how much it costs to survey a 100-acre farm?
I do not.
You care?
I don't have 100 acres, unfortunately.
You think it costs more to survey a 100-acre farm than it does a 3-acre off-conveyance lot?
I do.
Okay. Are you aware that prior to 1989, there was absolutely no process for approving off-conveyances?
I am aware.
Are you aware that off-conveyances were authorized in 1978 when the county adopted its agricultural zone? Or possibly before then?
Can you repeat that question?
The county created what's now known as the ag zone that covers 97.4% of the whole county land mass in 1978. Are you aware of that from your training?
I was not.
You aware of that from talking to people about special purpose plats?
I was not.
Okay. Are you aware that at that time, the county told people that owned agricultural land that instead of on a 100-acre farm, instead of the 80 lots you were entitled to, that now you're entitled to approximately 1 lot per 15 acres?
I'm going to object to the relevance.
He went into the history.
But you
of
can
special
answer.
purpose.
I'm just putting it on for the record, counsel.
I was not.
And are you aware that the agricultural community and property owners said, wait a minute, you're not going to make me go through a big, expensive, elaborate process to take a couple lots off for my kids, are you? And the county said, no, we're going to create off conveyances, which are very much simpler and
Objection.
very much
Is this
easier.
testimony or are you asking a question?
Are you aware of that?
I'm not.
Okay, all right. Is it true, and in 1989, are you aware that in 1989 the county adopted what are now pretty much the off-conveyance regulations?
I'm aware.
And are you aware that off-conveyance rights are more valuable than subdivision rights?
I think that's subjective,
Okay.
but it can be.
They are a property right, aren't they? They come from the property, right?
That's correct.
And property has to be eligible for it, right?
That's correct.
Okay. Now, can you describe precisely the process that a special purpose plat goes through?
Sure. So a special purpose plat is, first it's issued a file number through the county. As mentioned, it would be an amended plat file number, so an AP dash whatever number. It would be.
What's it amending, David? What's it amending?
It is, so the amended plat file number is not constituting that it has to be a plat to begin with. It's more or less a filing system for our records. So it's not necessarily amending any physical plat. It's more or less creating a way for us to follow it through the system, through the review process.
Okay.
So once it's submitted to the county, it will go to whomever is felt to be necessary to review it. At that point, they will issue their comments and move towards getting approvals from all those agencies, similar to the off-conveyance process. At that time, the plans will then be submitted to the county on Mylar paper, which is for archiving, and those will be circulated to those same agencies for their signatures and then be recorded with the circuit court with any type of easements that are required at the same time.
Would there be any environmental review conducted?
There can be for a special purpose plat. It depends what that special purpose is for.
Yeah, it depends on what the special purpose is for, right?
Correct.
Yeah. If it's to build something, there's an environmental review, correct?
There is.
And it's just as onerous or more onerous than what we went through, correct?
So the special purpose plat for this property would not involve any environmental review. That will be conducted with the off-conveyance process.
Okay, so you're saying that it would just be another step, but for this property, there would be 2 steps now. Special purpose plat, get it reviewed and approved, correct?
Correct?
Then submit an off-conveyance application to divide a lot off within that area described by the special purpose plat.
So I would say those two processes, I don't see any reason they could not occur simultaneously.
Okay, but it's still two steps, right?
Sure?
Okay. And the off-conveyance review is the same off-conveyance review that this one has already gone through, correct?
That's correct.
For a different piece of property,
You mean like a different portion?
different area of the property.
That's correct, yeah.
All right. And do you dispute John Lemmerman's testimony that there are significant review fees and cost associated with applying for and trying to get approval of a off-conveyance?
So all I'm aware of is the county review fees. I'm not sure of what Mr. Limmerman or any other land surveyor charges for their
I'm not asking if you're
services.
aware of what they do. Do you think they're significant numbers, or you don't even want to say?
I'm sure they are.
Okay. And what about the county review fees? What's
Those,
it cost, what's the cost of filing an off-conveyance application? Forget about the reviews, you know?
so I could tell you for this particular property, the review fees was $869.40.
It's to date.
Correct.
All right, that's all I have for Mr. Beecraft.
I have no follow-up.
I'm called John Lemmerman in rebuttal. John, you're still under oath, you remember that?
Yes, I do.
All right. You just heard Mr. Beecraft describe a process. You understood what he described, did you not?
I understood what he was saying, yes.
Yeah, well, what's your experience? What is your experience with these things?
It's an extra step. It's additional cost, additional time. And in my past experiences, you're basically going through the subdivision process and subject to a lot of additional regulations that pop up in the process because
Because once-
it is a process.
Because once you ask for permission from the government to do anything, and in this case, a subdivision plat, right? The code gives the government the ability to request stuff from you, does it not?
Yes.
Like easements,
Yes,
like road widening strips,
correct.
like maybe certain cases, maybe a hydrological study or something like that, depending on the area. No, I'm not talking about this case, but it gives the government the ability to put you through a harsher review, doesn't it?
It opens you up, yes, absolutely.
Does it cost more to survey a larger piece of property than a smaller piece of property?
Yes,
Significantly more,
yes.
depending on the size of the property?
And the topography, and yes,
Okay. And you would have to survey to do that plat, wouldn't you?
yes, to meet the Code of Maryland requirements, yes.
Thank you, that's all I have.
I have no questions.
Call Shorty Coon. Shorty, state your name and address for the record, please.
Walter Kuhn, 3033 Salem Bottom Road, Westminster.
How long have you lived, and remember, Shorty, they got to understand you, so do I. How long have you lived there?
Approximately 34 years.
And do you live there with your wife?
Wife, kids,
Your kids live there too?
one.
Okay, and is that the one that you're building a house for?
Well, he's gonna build a house. I'm trying to give him a piece of property that I'm having trouble giving him. So,
That's your son, you had two sons, right?
Yes.
One's named Cody.
Yes.
And that's here, and that's the one that is going to build this house?
yes,
If this is approved?
if this is approved.
Is this where you and Cody would prefer to locate the off-conveyance lot?
Yes, I would like to have it over there.
Why?
Well, actually, it's the only that I seen that had access to having a lot there. My understanding, I was actually accessible to have more lots,
Yeah, speak louder.
available on that. And, but this was the only position that I seen that we could pull a lot from that was perkable on my original 20-acre parcel.
And you knew that, that the add-on piece was off the table, right?
Yes.
At least you thought it was.
Yeah, I thought all that was off.
And so you looked at your property, talked to your son, and you decided on this location, is that correct?
Yes.
Why do you think this is a good location for you and your personal preferences?
Actually, it was the only location that I could find.
Okay, because of the topography and the steep slopes up by the
Yes.
pond, et cetera.
Yes.
Now, just a minute here. And so, at some point in your pursuit, this has been a long pursuit, like 4 or 5 years, correct?
Yes.
At least personally to you.
Yes.
Right. And at some point, you bought the add-on piece that the forest conservation variance is going through, correct?
Yes.
From a neighbor, right?
Yes.
You've been down there 20, 30 years, you get along with your neighbors?
I'll get along with everybody down around through there.
Okay. And you paid $15,000 for it, correct?
Yes.
And did that money come from your son?
Yes, it did.
All right, but it's entitled to you because you're entitled to the parent tract, right?
Well, we was gonna do that, and then when he gets the lot, then we'll just all be in his name, but he had to purchase it to get the right of way.
Now, were you informed at settlement that you were buying a piece of ground that was subject to a forest conservation easement?
No, I was not.
You acknowledged that it was likely that that was in your title pile or title report or something like that, correct?
Yes.
Do you know that, or you don't know?
I do not know that.
You found out about it about the same time John Lemmerman found out about it, correct?
Yes, yes.
All right. All right. Is Cody married?
Yes, he is now.
Children?
No.
Okay. He's living in your basement?
Yes.
All right. Let me show you what's been marked for identification as my 8. What's that? What's Exhibit 8 show?
That's actually a picture that I walked up in the woods approximately where the center line of the driveway would be, looking from the hill down to the road.
See it?
Jim, I'm sorry, I didn't give you
That's somewhere here.
And is it, did you take that picture?
Yes, I
That
did.
photograph?
Yes, I did.
About when did you take it?
Um,
A couple days before the previous hearing?
yes.
Okay, so a month or
About a
6
month.
weeks ago or so. Now, does that show where you believe the .08 acre driveway is proposed to be located?
Yes.
All right. Does it show pretty much the entire length of it? You know, if you look at the foreground to the pickup truck?
That's probably a little bit longer than the distance that we need to go through that property.
And how wide is it? 50 feet?
I think 40.
Okay, so there's a 40-foot swath that would go through that area, is that correct?
Right.
Right. Did you purposely manipulate that photograph to not show any bigger trees or any environmental features or anything like that?
Nope, I just took the picture where I knew or thinking the drive was gonna go, so.
I'm going to offer that into evidence as my Exhibit 8.
No objection.
Shorty, I'm not going to go through it all, but did you hear John Lemmerman test $1,000 pursuing these approvals?
It's in that area, yes, already.
Do you desire to, assuming the county would allow you, and they now say they would, do you desire to move the lot somewhere else? You want it where it's
Not at
applied
this,
for?
not at this point. It's not gonna be feasible for us at this point. We got too much wrapped up in this one.
Now, were you told by Mr. Lemmerman that you have all the approvals except this one, and you're 30, 60 days away from getting final approvals?
Yes.
And was your son anxious to obtain a building permit and start building a house?
We've been anxious for years. Get out.
Now, Shorty, you're aware, I mean, I informed you, and that as soon as I got the letter, that the county, Mr. Hine, was taking the position you had an illegal zoning use on the northern portion of your property, correct?
Right.
Right. And you're aware that that was referred to the zoning administrator for action. Is that correct?
Right.
Did you and I discuss that?
Yes, we did.
Did you tell me to talk to the zoning administrator and deal with that issue?
Yes.
Do you intend to deal with that issue as it goes through the zoning enforcement process?
Yes, we do.
Is it customary that the way that process works is that the zoning administrator tells you to fix it?
Yes.
You know what fix it means? Apply for a conditional use and get a site plan?
Right. And then get all that stuff done and then whatever's accordingly to be done.
Did Mr. Lemmerman, yourself, and me have a discussion as to what that might entail in terms of time, energy, and expense?
Yes.
That's all I have.
I have no questions.
Okay, that concludes our presentation.
Mine as well.
I do have a closing argument.
As do I.
I know everybody's anxious to stay here for longer, but
All right, presentation of testimony and evidence is now closed, and summations are in order. The applicant is first, then interested parties and protestants, followed by the applicant's rebuttal to complete presentation of the case. All right, so Clark, you go first.
all right, I'm going to start out, I don't know if it's the right foot or the wrong foot, but I believe this is outrageous to treat a citizen and taxpayer like this. He's entitled to the off conveyance. That's a property right. You either have it or you don't. He wants to exercise it. So he comes to his government and he asks them, or he applies to exercise his right. His own family, his own life wants it to be on this piece of his property, okay? That should be respected, and it is respected in our legal system. The desire of a property owner. The property owner does not give up all their rights when they apply to the government to exercise one of those rights. We know that. Now, how can the county, in good conscience, at the last minute, after all this work, and yet we probably got some fault in there. John Lemmerman said he didn't see it initially. I agree with him, though. Surveyors do not do full title, but you know, when we found out about it, we dealt with it, okay? And it was reported in the title cert. But for the county to allow somebody to go through all the way to this point, 6 months or, you know, whatever, and say, uh-oh, can't have it. Now, in and of itself, could be defensible under certain circumstances, but it's not defensible when the clear reason for this denial, I mean, with all due respect, can't get in Mr. Hines' head, as Mr. Allman has pointed out. It's very clear from the documentary evidence, it's circumstantial, and from the settlement discussions, that the real reason this variance was turned down was because of the contractor's equipment storage yard, which Mr. Hines continually refers to as illegal, a violation. Now, how would you like it if you applied for something and Mr. Hines' people came out to your property and they said, gee, is your wife selling antiques, or are you selling antiques from that barn? Uh-oh. I looked at the zone. It's a zoning violation. Your development plans are now on hold. We're not waiting for the zoning administrator. That's just his job. That's just what he does. And that's a process. We're not going to wait for that. We're not going to even hear your variance request, is what he says. Then, when I say to him, Chris, you can't do that, he goes, okay, denied. Then, when I say to him, then he says, I'm denying it because you can relocate up there, which he didn't say on the water resource easement. He didn't say on any of the other processes, but now he's saying it. I don't care when he knew about it. Now he's saying it. And we say, Chris, you can't do it. You can't relocate it. And he says, yes, you can. He goes back and he researches, or he talks to his people, and he comes back, he goes, I think there's a way you can do it. And we're just the department to give it to you. Because we're going to call it a special purpose plat. It's not allowed under the regulations. We have these policies, and for you, Mr. Kuhn, we're going to allow you to put it up there. And you know why we're going to allow you to put it up there? Because that makes my rationale for denying your variance work. Because you can put it up there. And that's what I need. And you know why I need that? Because we all know that you can't put it up there and you don't want to because you got all that contract equipment storage yard up there, boys. We ain't that dumb around here. We know what's going on. And that's what's happening here, and that's outrageous, and that's improper. Now, to get to the meat of the variance determination, I think we've shown more than enough hardship, especially when you start balancing the uses. I hate to rely on common sense because I'm a lawyer, but 0.08, you saw the forest bank. And by the way, in the ordinance, forest banks are required to be good forest. This forest might be priority 1, but I'll bet you it wouldn't qualify for a forest bank, but I don't know that. So you've got an incremental benefit that Mr. Hine wants to attain. Let's assume for the sake of argument that he doesn't want to attain the contractor's equipment storage yard getting cleaned up. He just wants to attain the benefit that would accrue from taking 0.08 acres and putting a driveway up through that and replace it for it. That's the benefit. And he looks at the detriment, if he did at all, and says, nah, the balance is, you know, I'm not giving the variance. You know, there's nothing on the other side that outweighs my environmental benefit. I'm going to get that. Now, we've tried to show testimony that there's environmental enhancement. It's clear that if you didn't have a 3-acre environmental variance and you're going to get one now, that's a benefit. You know, prior, it's clear. The other thing I'd like to say is that the premise that Mr. Hine apparently has adopted, which is that if you can relocate, you can't get a variance. Now, he basically said that explicitly. That's not the analysis. And you can imagine, first of all, it's not legally the analysis. Secondly, you can imagine how that would never be the standard based on my hypothetical. I mean, there's often, this is a unique piece of ground, this is a tough piece of ground, but there are often other places you can put them. And then you get into the, well, you could put it over there, and then the guy goes, yeah, but I've got to put a 600-foot driveway in if I put it over there. Oh, yeah, okay, that's a disturbance. You got to get through stormwater. But that cannot be the criteria, and it is not the criteria for denying this variance. This variance was denied because Mr. Hine wanted the contract equipment storage yard to be cleaned up. And then the settlement discussions, which are in the emails, wants it just confirm that. What did he say? Hey, I went back and said, you can do, we've invented, well, we're going to use it, we're going to be nice people. We're going to give you a special purpose plat, and we're going to let you do that. And again, we're going to let you do that, I say, because it makes my variance denial work. And the real reason here is that contract equipment storage yard, that's impermissible. We're asking this board to, de novo, to decide not whether or not you agree with Chris Hine. to decide whether or not, based on the evidence before you, you would grant this variance. Because that's the position you're in. You're not in a position of seeing whether Chris Hine is right or wrong. You've heard the evidence today. And it's your job to decide whether or not, based on the law and the language and the testimony, you would grant this variance. I thank you very much for your attention. I know it's been, I don't know what it's been, but I thank you for your attention.
5 hours.
And appreciate your attention to the matter.
Thank you. Okay. First of all, board members, I just want to thank you for your time and attention to this matter. I know it's, you know, it's been a long day. A lot of testimony's been heard, and I just really appreciate you guys sticking through it. So, as counsel said, you are here sitting de novo, which means you are making your decision based off of all the evidence and testimony that was presented here today, not on the mindset of Chris Hine. When we're done today, the record, it doesn't matter if Chris Hine made this variance decision. It doesn't matter if Christopher Columbus made this variance decision. That is up to the board. Now, why are we here? We are here for an appeal of a forest conservation request, an appeal that was filed by the property owners on August 22nd, 2022. That forest conservation variance request was based off a denial of a variance request from RTF Associates, which has been entered into evidence as Opposition Exhibit 2, I believe Applicants Exhibit 5, on May 18th, where they say, pursuant to Carroll County Code 150-33, we are hereby requesting a variance from the technical requirements from Carroll County procedure for release of forest conservation easement, that the priority one forest is not eligible for release of easement. And we are requesting release of 0.084 acres of existing forest conservation easement that is partially in priority one forest, and they go on to say that the location of their lot was not haphazardly chosen, that they even use the word ideally. The lot would be on the use of the existing driveway access located on the north side of Morgan Run, making it a much more cost-effective option. Now, they further say that it was deemed not possible to do the off-conveyance on the northern side due to possible steep slopes, which when you look at our Exhibit 3, or 2, you can tell that there are steep slopes, or that the northern portion of the property is not encumbered with so many steep slopes, that it's actually almost significantly flatter than the southern portion of the property. They also mention existing improvements. There's the existing house and the alleged contractor's equipment storage yard that's not in compliance, that was put there by the applicants, the property owners. And their third reason why they couldn't put the off-conveyance on the northern side of the property was the associated well and septic area. And it was determined that using any usable ground on the north side of Morgan Run would not support a sewage disposal area, just potential septic system replacement for the existing house. You heard testimony and you saw from Opposition Exhibit 3 that the type of soil that covers the northern side of the property, that B type of soil, is a type of soil that would allow for a septic system to be installed on the property. So that request went to Mr. Hine, and on August 15th, 2022, Mr. Hine sent a letter to Mr. Lemmerman, Mr. Schaefer, and the applicants denying the forest conservation variance request. And in his denial, he goes through the relevant portion of the chapter 150-33, which is the variance portion of the chapter. And that variance portion of the chapter says the county may grant a variance from any technical requirements included in this subchapter if there are exceptional circumstances that such strict adherence to the provisions of this subchapter could result in unnecessary hardship or environmental degradation. Unnecessary hardship is a legal term of art. The Maryland appellate courts have case law defining what unnecessary hardship is. The applicant claims that their unnecessary hardship, which is the right to develop the off-conveyance on the northern or on the southern part of the property, because the northern part of the property is just unsuitable for all development, where we have provided evidence and testimony showing that an off-conveyance residential lot can be built on the northern side. And in fact, the applicants had said it would be ideal, it would be more cost-effective to put it on the northern side. That the applicant asserts that due to several factors, development of the off-conveyance on the north side of the property is not feasible and must occur on the southern side. We went through the data. The applicant stated that he is a contractor by trade who performs percolation tests, installs septic systems, and it was determined that any usable ground on the north side of Morgan Run would not support a sewage disposal system, just a potential septic replacement for the existing house. Again, Opposition Exhibit 3 showed that that's Type 3 or Type B soil that covered a majority of the property. It's the type of soil that is conducive to allowing such septic, allowances or permissions on the property. Moving forward, there has been a lot of discussion about the site plan process and all the processes and the costs of the process and how much time it takes. When it was testified to that the forest conservation easement that they are seeking relief from was on the plat prior to the applicants getting Mr. Lemmerman's services. And as it is recorded on the plat, in Maryland, that means it's on constructive notice, which is another legal term, which basically means if it is recorded, it's on notice for the whole world. It's a legal fiction that if it's recorded, that everyone in the world knows about it.
Jim, it's not on a plat.
The forest conservation easement was recorded.
Yeah, but it's not on a plat.
It was the forest conservation easement was recorded, and because it was recorded, the legal fiction continues that it is on notice to everyone in the world. Now, furthermore, there has been a lot of testimony about the tedious, expensive process that this is going to, and council's sort of newfound indignation that developing in Carroll County takes time and costs money. That the hardship is the amount of time this takes and the amount of money it costs, when that is what the code provides for. County staff did not do anything outside of what the code calls for. They followed the code to what it calls for. Yes, it takes time. Yes, it costs money. But that's the process that the county has, and that is not a hardship. That is not a hardship, a relevant hardship for a variance request. I mean, if you accept their argument that following the county code and the process takes time and costs money, then every developer, every land use attorney would say, oh, I mean, look at this development I've tried to do. It's taken so much time, so much money. Environmental regulations, subdivision regulations, any regulations, they're irrelevant because look how much this has cost. Look how much time this has taken. That would hollow out and basically make the code not mandatory but advisory. Just something, yeah, you can follow, but if it gets too expensive, don't worry, it doesn't apply to you. There's no case law that was provided, or no authority that was provided, that shows that hardship, that a variance hardship is something, let me rephrase that. There's no authority from any court in Maryland providing that an unreasonable hardship is following a county code, is following the law of the land, the ordinance. There's also been a lot of discussion about the minimal acreage that would be disturbed for the driveway, 0.08. And while I sympathize with them because that is small, that's still the law. That's still the law. They still need to apply for a variance from that. It doesn't matter. It could be 100 acres. It could be 0.1 acres. If they disturb that, they need a variance from it. So just in conclusion, the county followed the steps and the law and the code that is provided for by the Board of County Commissioners. Yes, it's expensive. Yes, it takes time to develop. But the applicants, that is not a hardship under the variance hardship standard. The applicants have not met the variance hardship because they are able, and according to their variance request, would prefer to have the off conveyance on the northern portion of the property rather than the southern portion of the property, which has been so expensive, so time consuming, whereas they said in their original variance request that it would be more expensive to do it on the, to put the off conveyance and the development on the southern portion, and that is something that the property owners decided to do rightly for themselves. But again, it's not a reason to grant a variance under the code as it exists. Thank you.
Briefly, I find it interesting the amount of emphasis that the county puts on Mr. Lemmerman's letter. This is not a court case where we've got a pleading and strict rules of pleading. Let's assume Mr. Lemmerman was wrong on his statement that that it wouldn't be good to go or wouldn't work on the north side of the property for the reasons he stated. What we do know, and let's assume he's wrong, you can't just say, well, I'm denying the variance because you said that, and now I think it's not true. You've got to look at the whole variance thing and see if the guy's entitled to a variance. It'd be like if we would have alleged there's a big rock somewhere, and it turns out it's not true, but there's other evidence in the case that indicates a variance, you get the variance. In fact, Mr. Lemmerman should have said in here, you can't put it up there because it's an add-on parcel. He didn't think of that at that point in time, which was true until they invented the special plat. But does that mean you don't get a variance because you put that in and didn't think of it? No, it doesn't. And this characterization of, we said we'd prefer the location up there, that is not what we said. You heard the testimony. We prefer to put it where we are. What we said is that would be cheaper and da-da-da-da-da, in the, as I just referred to. The county didn't go outside the code. Mr. Hine didn't go outside the code. You heard him up here today when he cited that. He brought it up himself, the compliance section of that code, where he says, basically, I've made a finding that you got a zoning violation. And therefore, here's the code, you're dead. He can't make that finding. That's outside the code. That's not the way the system works. And if there's any doubt as to the real reason for this, the contractors come to storage yard, it's elucidated in the settlement negotiations. What did Mr. Hine do after we said we couldn't put the off-conveyance up there? He said, yes, you can, therefore no deal. The 1% has come in, okay? No deal, no variance, because the deal was you get a variance if you can't put that thing up there, okay? He says, no, you can, no deal. But what did he say? However, I'll give you a variance if you clean up the contractor's equipment storage yard. That's what's really going on here, and that's improper, okay? That reveals the true intentions here. It's not a matter of, can you put it up there? It's a matter of, you got the, and circumstantially, I mean, you're not potted plants. I mean, you're allowed to think and infer from evidence put in front of you. I would argue to you that the sequence of those letters combined with the settlement situation, you can conclude, but I don't have to have an email from him saying, hey, John, we're going to turn this down because this, we're going to try to clean up. I don't have that. But I've got enough, and more than enough in my experience, to show that that was the improper reason this variance request was denied, and furthermore to show, or at least argue to you, that the mere fact you can relocate is not a DQ, assuming you can with that special purpose plan. Now, in terms of the hardship, yeah, it's not a hardship to comply with the county code. I'm not saying that. It's a hardship to comply with the county code times 2 or 3. Meaning, go back and start over. You've gone all the way through here. And, if you're a lay person, which Shorty Coon is, you got to say to yourself, well, why didn't somebody bring this up sooner? February 22nd, John, they knew it's been discussed. You were out there for your water resource conservation easement. You gave it to me. In that decision, you said, I don't think you can use the other piece of your property. Then, after he found out about the contractor's equipment storage yard, all of a sudden, he discovered, I think you can use that piece of your property, and turned down the variance. I think it's improper, and I don't think it's correct. And I think there is a hardship here, and I emphasize, I don't think this is a variance. Variance is a term of art, but it's in the zoning codes. These are environmental variances. They're different animals. They're a matter of weighing the, balancing the interest, and I think the code supports that, and the relative benefit here to the environment. That's what we're here to create an environmentally decent earth, including Carroll County, and these ordinances are designed to do it. The question is, does this do it? Is this what we need to do to tell a private property owner what we've all said? That's what we need to do to get a decent earth when you bounce. And again, I want to emphasize, if we do go somewhere else, we're going to have environmental effects. We don't know what they're going to be, but they're going to be environmental effects. Tough piece of property. My client owns it, wants to. So we appreciate your concern, your attention.
I have a quick rebuttal to that rebuttal.
Well, it's not customary, because if you rebut, I'm going to rebut.
Are we just going to keep doing that until the cows come
Well,
home?
no, the rule is it ends here.
Fine.
I'm here as the appellant.
No? Okay. Let's close.
Questions right now, which-
No questions. Just go.
We're gonna go into recess, discuss the matter.
first of all, there's a lot of debate on this case. It's a lot of information and misunderstandings and things that go on that from you, the owner perspective, and from the county perspective, all kinds of unknown things that are hanging on there that affect the outcome of something like this, and it's a very difficult thing, and we deliberated, I mean, even though we might not have taken a lot of time, although this has been a pretty long case, it was difficult. It was difficult. So where I come from is that the decision was made by the owner back in 2018 to start gathering data and information and surveying for the southern plot to get all the information you needed to build there. And at that point, when you launched in, you started spending that money, you didn't have any idea that there was a forest conservation area there. You didn't find that out until early 2022. By then, you had spent all that money. And then you go ahead and at that point, you had no reason to believe you were going to get turned down, so you asked for the request for, for the forest conservation request to be able to build there. And at that point, you were rejected, and well, I guess you found out in February, March or something about that there was a conservation area, and that by that time you'd spent all that money. And then you went ahead and you issued the request for the variance, and then it went to the county, and then the county comes back and says no. At that point, I feel like even though a lot of information is cut out, that's been presented here, a lot more detailed information that was not available when you went ahead and requested the variance. So a lot of information is still coming out. But still, the responsibility, in my opinion, is on the owner, even though you may not have known that there was the forest conservation area, you're still responsible. I mean, it's not responsible for the county to tell you that that's something you're responsible for. I can see myself, by the way, getting in the same situation you got into. Because how would I know? How would you know if it's not on the plat? It wasn't on the plat. I don't know whose liability is for not having it on the plat, but it wasn't there. So, but ultimately, you made the decision, spend the money. This is where you wanted to go. I'm sure it's aesthetics. It's a beautiful place to build a house and live, and you prefer that than the northern part where all the clutter and infrastructure is. And so you went ahead and did it. And then the county comes back and says, well, for 3 reasons, we can't grant you that because you can build in the northern part. And there's complexities on that. What is the answer to building in the northern part? And there's issues on that, like the extra land. But ultimately, I just felt like the responsibility is on the burden for the owner to, that you made the money. It's not a hardship. It's a risk that you took. You didn't know it at the time, but it's a risk that you took to spend that money to find out where you wanted to build a house, but then you got rejected, and now you want to call that a hardship. And to me, it's a risk. To me, it's again, it's a shame because as I said, I see myself doing the same thing, and it is what it is. And the county regulations and the procedure that you have to follow is going to double your costs. Yes, it's something you're going to have to, that I feel you're going to have to go through. And I don't know at this point who to blame. I think part of land ownership and things is a mystery to a lot of people. There's a lot of information. You know, in retrospect, maybe you get a lawyer when you go through this process to start digging and searching and finding out, and then that conservation area would have been identified early in the process, would have saved you money and time and everything else, but you didn't know. So again, that's my opinion.
But you're allowed to ask for a variance.
We'll have to ask. That doesn't mean we have to.
That doesn't mean you're going to get it.
I'm well aware of that. You're allowed to ask for a variance. It just because you have an easement on your property doesn't mean you're dead. You ask for it, that's why this, anyway.
Right.
That's why the system has a variance requirement in it to address these situations, I think.
I'm all done.
Do you want to go?
Sure, sure. Yeah, I agree with a lot of what Kurt said. I feel this is kind of a, well, one, it's been a really tough decision to make, and I feel like it's an unfortunate set of circumstances that has led us to this point, that more diligence, due diligence, more communication would have probably saved a lot of time and money. But I do feel like whatever hardship, argument you make for a hardship has also been self-inflicted. So I also worry about the precedent that this would set. Somebody buys a property, makes a claim later on, well, I did not know that it was conservation, and then asks to be able to use it for a certain use. I think those are, yeah, and also I also feel like you do have an option to move forward. It might not be the one you want, and maybe there's a way to still work things out. I'm not sure. So I don't think this absolutely shuts the door on you building on your property. So.
I agree with my colleagues, and in addition, I'd like to add that based on the evidence, I don't believe Chris Hine acted in bad faith. And I also don't believe that there would be a significantly net improvement to the environment. Even though you're adding easements, there would be considerable disruption to the environment, bulldozing and building on that steep slope and disturbing all that soil in that forested area. And on that note, I'm open to taking a motion to deny the request for variance. All who agree to deny, say aye. Or I need a second, yes.
You need somebody to make them.
I need a second.
I
you said so
move
yes, thank you.
that we reject the request for variance by the Kuhn property.
I will second that motion.
All in favor, say aye. Aye.
Aye.
Thank you for your time.
Written decision which will be issued within 30 days unless otherwise extended by the board.
And then there's an appeal right?
That'd be in the decision,
That'll be in the decision?
yes.